The Supreme Court ruled decisively, affirming that judicial appointments and tenure must be protected from executive interference. It was more than a legal victory. It was a declaration that the judiciary is not subordinate, but co-equal. In that moment, the court defined
Honorable members, can we please take our seats? Please, if you know you are to sit down and you are still outside, please come to the auditorium and take your seat so that we can make a start to the program. Let's please take our seats. We are having our dignitaries enter the venue in some few minutes. Can we take seats? Please, in the next 10 seconds, we want to see the place in order. Kindly take your seats. If you are aware that by protocol you are to join the Honorable Chief Justice to usher him into the auditorium, kindly make your way out to the holding room where he is so that we can process into the auditorium. I take that again. If you know that by protocol arrangement you are part of the team to usher in the Honorable Chief Justice, kindly go to the holding room where he is and join him as he's about to be ushered into the auditorium. ushers, kindly ensure that we have everyone sitting. We have spaces in between people. Make sure we fill the auditorium. I can see people standing.
Something you like to do. 这东西我们素食系什么？And then Mr. Mamoon, also set focus of the practice station. Notice then yeah, I could do it. Yeah, from almost a centimeter. Woman for street.
Honorable members, shall we rise as we have Justices of the Supreme Court of Ghana, Ashedi? My Lord Justices of the Supreme Court, you welcome. President of the Ghana Bar, the Vice President of the Ghana Bar Association, Mrs. Victoria Bang, President of the Ghana Bar Association, Mr. Kwame Owusu-Sechwe. Please take your seat. As we await the arrival of our other distinguished personalities, by way of information, kindly take notice that there are washrooms to either side of the auditorium. If you have to attend to Nature's Call, you exit to your right, there are washrooms there. You exit to the left, there are washrooms available. By way of safety information, in case of any emergency, we have exit gate. You take your right, you see the exit gate. You take your left, you see the exit gate. We know there will be no emergency, but take precaution. Thank you. Respectfully, shall we be upstanding? Shall we be on our feet as we usher in Chief Please take your seat. Thank you. Shall we now have the national anthem?
Please kindly take your seats. Thank you very much.
Good morning, Your Royal Majesty Otumfuo Osei-Tutu II, the King of Ashanti Kingdom. Good morning to His Lordship, the Chief Justice of Ghana, the Regional Minister, Minister of States, Chairman of the Supreme Court Planning Anniversary Planning Committee, distinguished guests, members of the judiciary, members of the bar, ladies and gentlemen. It is with great honor and pleasure that I warmly welcome you to the 150th anniversary of the Supreme Court of Ghana. Under the theme, honoring the past, celebrating the present, and defining the future. Today we celebrate a remarkable milestone, that is 150 years of the Supreme Court of Ghana, an institution that has remained a guardian of the Constitution, protector of rule of law, and guardian of justice. This celebration is not only a reflection of our rich cultural judicial history, but also a tribute to men and women whose unwavering dedication, integrity, and service have shaped and sustained the administration of justice. Ladies and gentlemen, Nananom present, please, a round of applause for all of us for our dedication to this journey. Nananom present, ladies and gentlemen, my name is Monique Ohnewan Kroma, and I'll be the MC for this program, and I'll be doing this with the Regional Bar Secretary,
Shadrach Obin Yeboah. Otumfuo, my Lord the Chief Justice, Justices of the Superior Court of Judicature, Heads of Security Agencies present, President of the National House of Chiefs, Regional Minister, Mayor of Kumasi, distinguished ladies and gentlemen, seeing how beautiful this place is looking and how gorgeous we are looking, I think we also have to give it to the planning committee for putting together this wonderful event. We thank you also for making it to this event. It is your presence that is making it great, and we truly appreciate it. We would formally start the event with an opening prayer. And with this, if I may call upon His Lordship Justice George Akins Ampia Boni, a very right reverend, Justice of the High Court and a minister of God. Shall we welcome him with a round of applause?
Respectfully, let us sit reverently and bow for a prayer. O God, our help in ages past, our hope for years to come, our shelter from the stormy blast, and our eternal home. O Lord God, who reigns enthroned in heaven on high, we praise thee and bless your holy name with humble and grateful hearts for your faithfulness through the generations, and for the men and women which you have served in this land through justice. We pray, O Lord, that the truth and common good, acknowledging that it is you who fashioned the hearts of rulers and judges and granted them wisdom, as we gather to mark the 150 years of the Supreme Court of Ghana, grant us clarity of mind and purity of intention, so that our deliberations may reflect equity, truth, and clarity. Bless this assembly, we humbly beseech thee, of kings and queens, judges past and present, legal scholars, chiefs and traditional rulers, civil servants, students, and other august guests which seek common welfare of this nation. Fill our hearts and minds with reverence for the rule of law, and steady our tongues to speak with civility and courage. Let every argument be tempered by sober judgment, and every conclusion informed by the historical fidelity, and every proposal guided by the concern for common good. We humbly beseech you as we gathered here to bless and protect the President of the Republic of Ghana, His Excellency John Dramani Mahama, and his executives and cabinet. We entreat you, Spirit Divine, to bless His Royal Majesty, Otumfuo Osei Tutu the Asantehene. Preserve him in health and grant him wisdom and much more discerning spirits. We pray in a special way for our Honorable Chief Justice of the Republic of Ghana, His Lordship Justice Paul Bafo-Boni, his administrative staff, the diplomatic corps of venerable Supreme Court judges, and the rest of us, the judiciary at large. Endow him with complete good health and continued grace to lead the judiciary. May our presence here, O Lord, foster and honor mutual bonds between institutions of chieftaincy and the courts of our land. Lord Jesus, fountain of justice and mercy and righteousness, Eliminate our discussions between chieftaincy and the Supreme Court. Guard the speaker and listeners alike. We entrust this lecture and the outcome of its care to the Holy Spirit fidelity. May our deliberations be for the enrichment of justice and our traditions to flourish every community and to honor traditions while securing the rule of law. To you, O Lord, the Father, Son, and the Holy Spirit, be all honor and glory forever and ever. And let us all end with the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. Thank you.
Thank you, His Lordship, the Very Right Reverend George Akins Ampia Bonny. We're having this beautiful event as a result of the work of the planning committee. Having gathered here, I think it's only appropriate that we take a welcome address from the chairman of the planning committee for the Supreme Court 150 years anniversary celebration. The chairman is somebody we have known on the bench. He's one of the people you can call career bencher, having started from the district court and risen to the Supreme Court. May I, with respect and humility, invite
Your Majesty Otumfuo Osei Tutu II, my Lord the Chief Justice of the Republic, my Lords Justices of the Supreme Court of Ghana, my Lords and Ladies Justices of the Superior Courts, Judges and Magistrates of the Lower Court, my Lord Spiritual, the clergy, Oji Ahoho Yaujebi, President of the National House of Chiefs, Nananom of the National House of Chiefs, distinguished speaker for the occasion, His Excellency Ivor Ajimaindua, the Honorable Regional Minister, Honorable Mayor security agencies, heads of government departments and agencies, Nananom, Nanahimanom, lecturers and students of our law schools, distinguished invited guests, media, ladies and gentlemen. On behalf of His Lordship, the Chief Justice of the Republic, and the Judiciary of Ghana, it is both an honor and a solemn duty for me to welcome you to the second in the series of lectures to mark the 150th anniversary celebration of the Supreme Court of Ghana. And permit me, in all humility, to specially welcome His Royal Majesty Otumfuo for making time to spend this day with us. And permit me further to appreciate Otumfuo's princely treatment of hosting us in this beautiful edifice. The choice of Kumasi for this lecture was not by the toss of a coin. It was a mandate draped in curtsies. Kumasi is the citadel of chieftaincy and culture. It is here the institution is epitomized. Certainly, the wheels could not have turned anywhere else. By receiving us here, Your Majesty, you are not only playing a royal host, you are contributing to the administration of justice, the building of Ghana's constitutional democracy. Planning this celebration under the theme, the Supreme Court at 150, honoring the past, celebrating the present, and defining the future, we conceived of the creation of various fora for interplayers of justice delivery to meet and engage. Far from indulging in a mere institutional talk shop, this engagement is to engender a collective inquiry into the past of the administration of justice, assessment of its present state, and how to aspire into the future with hope. And let me state with due clarity and commendation that the institution of chieftaincy was the originator of justice delivery in our society. Before the advent of the colonial courts, before the enactment of the first colonial ordinance, and indeed, before the conception of any modern court building in this land, it was the chief, the Queen Mother, and the traditional authority, however designated, that stood as a primary forum for the resolution of disputes. The customary processes of mediation, conciliation, and arbitration conducted under their traditional governors were not mere informal gatherings, but were structured, regulated, and deeply respected mechanisms of justice. And doing this, Nananom prioritized restoration over retribution, community harmony over individual victory, and conventional wisdom over bookish technicalities. The honor, therefore, goes to Nananom, whose forebears laid the groundwork for a system that the world would now seek to emulate. Distinguished guests, our thoughtfully selected topic for today's lecture, the Supreme Court and the institution of chieftaincy, the past, present, and future, was formulated upon our firm conviction that the noble institution of chieftaincy, as established by customary law and usage, and which is unavoidably guaranteed by the 1992 Constitution, must continue to be recognized, revered, and appropriately empowered. For it is a legitimate and significant component of Ghana's pluralistic legal order. The past has shown that chiefs can and do deliver unalloyed justice. The future must be one in which the Supreme Court and indeed the entire judiciary and the institution of chieftaincy work not as rivals, but as hand-in-hand partners in the noble pursuit of justice for the ordinary Ghanaian. Our speaker for today is a polymath. There is no doubt that he will be erudite in delivery, do justice to the subject, and leave us all well-fed with profound schooling. Our panel of discussants will help digest the issues, excite frank comments, even criticisms. The essence is to ensure that the learned justices of our courts leave this forum better enlightened in customary law usages and matters related to the institution of chieftaincy and its procedures. Once again, I welcome you humbly to this forum, and I thank you for your attention.
Thank Thank you very much, the chairman of the Supreme Court's 150th anniversary. Please, another round of applause for him. He has done so well in putting this program together. Please, I would like to call on Ekwe Nyako Esquire to introduce the chairperson of this program.
His Royal Majesty Otumfuo Osei Tutu II Asante-Hene, the Honorable Chief Justice of the Republic of Ghana, His Lordship Justice Paul Bafuboni, Chairman of the Supreme Court at 150 Committee, His Lordship Justice Ajay Frimpong, President of the Ghana Bar Association, Mrs. Ifua Gate, the Honorable Ashanti Regional Minister, Justices of the Superior Courts of Judicature, Justices and Magistrates of the Lower Courts of Ghana, President of the Ghana Bar Association, Ashanti, former leaders of the bar, honorable members from academia, Nananom hearing present, heads and officers of security agencies present, seniors and colleague members of the bar, ladies and gentlemen, you're most welcome to this event. Respectfully, my name is Ekwe Nyako Entry, and I am delighted and honored to be called upon to introduce the chairperson for this event. I will first introduce our chairperson as Excellence. Born in 1950 in the Western region of Ghana, he trained initially as a teacher at Seshwi Wioso Teacher Training College, now Seshwi Wioso College of Education. Taught for a period of time, then proceeded to the University of Cape Coast for a Bachelor of Commerce degree alongside a diploma in education. He holds a certificate for alternative dispute resolution, a credential that has underpinned his role as chief mediator in the chieftaincy disputes. In November 2016, he was elected president of the then Unitary Western Region House of Chiefs and was sworn in by a Sekondi Takoradi High Court judge. He continues to hold his post representing the Western North region at the National House of Chiefs, acting as a chief mediator for chieftaincy and traditional disputes in the region. He was elected to the National House of Chiefs on 12 November 2020, and due to his good leadership and work ethic, he was re-elected into office. In May 2017, he was appointed to the board of the Ghana National Petroleum Corporation. He has also been active in soliciting funds for educational institutions in this region. He was recently awarded a prestigious gold medal by Otumfuo Osei Tutu II in recognition of his exceptional commitment to peace, unity, and outstanding service to society. Our chairperson is the Omanhene Paramount Chief of the Seshwi Anyaso traditional area in the Western North region of Ghana. With a round of applause, giving honor unto whom honor is due, let us welcome the President of the National House of Chiefs, Oji Ahoho Yaojebi II.
Your Royal Highness, Otumfuo Osei Tutu II, the Asante-Hene, Nananom, Your Lordship, the Chief Justice of Ghana, Justice Paul Bafuboni, Justices of the Supreme Court of Ghana, justices of other courts in Ghana, President and other officers of the Ghana Bar Association, members of the legal fraternity, honorable ministers here assembled, Honorable Regional Minister Dr. Frank Amoako-Hene, honorable members of Parliament, Mayor of Kumasi and other MMDCs, other government officials, members of the security services, His Excellency Ivan Agyemang-Duah, a distinguished academic and economist. Reverend ministers present, members of other religious bodies, Nananum and other traditional leaders, invited guests, distinguished ladies and gentlemen. Officially, yes, my age is 1950, but my parents were not educated, so later on, when I went through the records, I realized that I was born in 1948. Meanwhile, in all my records, including my passport, is 1950. So I just want to tell you that I am 77 years old now. And I'll be 78 in October this year. Good morning. I bring you royal compliments from the chiefs and people of Sehuamiaso, the Western North, and the National House of Chiefs. I very much appreciate the honor done me and the National House of Chiefs by the kind invitation to this important ceremony. The anniversary lectures of the 150th anniversary celebration of the Supreme Court of Ghana being held under the auspices of His Royal Highness Otumfuo Osei Tutu Asante-Hene, who I revered very, very well. And I am always excited when he refers to me as his father, because at a certain point he was saying in Sefi, Your Royal Highness, thank you very much. On 2nd April 2026, the Supreme Court of Ghana officially launched its 150th anniversary commemoration of judicial service since its establishment under the Supreme Court Ordinance of 1876. This anniversary celebrates a court that dates back from colonial days and evolving over time to become an influential institution as the apex of the judiciary system of Ghana, and assuming powerful stature as the third arm of government with the exclusive mandate for the interpretation of Ghana's constitution. The Supreme Court of Ghana exists to serve as the highest court of the land, exercising exclusive jurisdiction over constitutional disputes while functioning as the final appellate body for all judicial matters nationwide. It also oversees all other courts and adjudicatory bodies in Ghana, ensuring the proper administration of justice across the country. I have learned the celebration is a month-long event spanning the whole of July 2026, featuring an array of activities designed to engage the public and legal fraternity. The celebration of anniversary allows for reflection on the shared journeys, the milestones, the challenges, and provides opportunities for learning from what worked and what didn't work. It is also for further strengthening of corporate visibility, public identity, and the Supreme Court of Ghana, and bonding with stakeholders. This 50th anniversary of the Supreme Court of Ghana centers on the theme Honoring Past, Celebrating the Present, and Defining the Future. It focuses on assessing the judiciary's evolution, improving public trust, and calling for modernization and technological advancements, shortening the time of justice delivery. Today's event, however, which is under the topic, the Supreme Court and the Institution of Chieftaincy, the past, present, and the future, hosted under the auspices of Otumfuo Osei Tutu II, will include a major anniversary lecture and community outreach program. Today's lecture will, among others, explore the historical and contemporary role of the institution of chieftaincy and the nuances between the Supreme Court and the chieftaincy institution as educating entity in Ghana. Chiefs had in pre-colonial times been the sole custodians of justice delivery in the society and various communities. In contemporary Ghana, the institution of chieftaincy is a legally recognized system of traditional governance operating alongside the modern democratic state. Protected by the 1992 Constitution of Ghana, chiefs primarily hold administrative, customary, and adversarial roles rather than executive or legislative powers. The institution of chieftaincy plays a critical, formally recognized role in Ghana's justice delivery, operating as a dual system of formal statutory education through the traditional councils, regional and national houses of chiefs, and informal, customary arbitration of the traditional and community level. It is heavily involved in resolving both internal traditional disputes and community level civil conflicts. Today, in spite of the phenomenal growth in our court system, the institution of chieftaincy continues to contribute immensely to justice delivery by educating cases in our communities, settling disputes to relieve the court system of its heavy case load. Without the education roles of our chiefs in various communities, there is no way peace and harmony could thrive in our community. The educational role of the chieftaincy institution in Ghana is expected to continue into the future. We must realize that in every community, in every town, in every village, there is a chief. Democracy and citizens' expectations. Your Lordship, the Chief Justice, Nananom, ladies and gentlemen, Ghana has opted for democracy and the rule of law by adoption of the 1992 Republican Constitution. Democracy is also rule of law, and as citizens, we expect more transparent and fair application of law, expansion of citizens' freedom, and speedy delivery of justice. Our course should work hard to eliminate the public perception of political polarization and also improve public confidence in the judicial system. We expect to see extensive growth in the application of technology in justice delivery, such as electronic recording in every courtroom to preserve records, boost transparency, and eliminate disputes over proceedings. We also want to see improved accessibility to the justice system by all citizens equally before the law, for the rich and poor, vulnerable and powerful, and speed justice delivery as delayed justice erodes public confidence. Accessibility and speed could both be facilitated by expansion in alternative dispute resolution mechanism and reduction of the cost of litigation. Your Lordship, His Royal Majesty, Your Lordship, the Chief Justice, Nananum, ladies and gentlemen, with these remarks, I humbly accept to chair this function and kindly implore you to assist me steer the function to a successful end. Thank you for the opportunity. Thank you.
Please, a big one for Nana, the chairperson for this event. Thank you very much, Nana. Nana, we are reminded that, and distinguished guests, we are reminded that as we continue this historical celebration of the Supreme Court's 150th anniversary, we are reminded that every discussion today contributes to shaping the future of our justice system while honoring those who laid the foundation for us all. We'll take a cultural presentation from the cultural troupe, then the program continues. Thank you very much.
Thank you for that wonderful display of culture. We appreciate it. Honorable members, invited guests and dignitaries present, we would move on to the next item on the program. But before I do, now that we have a chairman for today's occasion, I would want to introduce some of our dignitaries present. As we go along, we'll keep introducing them as part of case management strategy. As my laws justices will always say, even though we have not filled or signed any document over here, we are still guided by time. So I'll proceed. For the Supreme Court, I'll start from the Supreme Court. We have with us His Lordship, Justice Gabriel Paulman. We are also blessed to have His Lordship, Justice Emmanuel Yoni Kolendi. My Lord, you're welcome. We have His Lordship, Justice Samuel Kwame Adibu Esiedu. We are also privileged to have His Lordship, Justice Ernest Yaogayu. We have already introduced the chairman of the Anniversary Planning Committee, His Lordship Justice Richard J. Frimpong. Next, we have His Lordship Justice Senor Jamefe. And we have His Lordship Justice Sir Dennis Dominic Eji. We are fortunate to have with us the Judicial Secretary, Mr. Ahmed Musa. We also have with us the President of the Association of Magistrates and Judges Ghana, Her Ladyship Justice Olivia Obin Owusu. We have mentioned that we have the President of the Ghana Bar Association, Mrs. Efua Gati. I am particularly excited that we are having this event here. And it is because we are talking about chieftaincy and looking back to 150 years where we are satisfied of a lot of groundbreaking achievements by our Supreme Court and the setting of records and precedents. And for this to happen in Kumasi, as the chairman said, it's not as a result of a toss of coin. It is as a result of a careful choice made upon facts that can be justified. Once we are lawyers, we always look for that, the justification. And talking about the National Bar President, it was in Kumasi that we made history, where the Ghana Bar Association had the first female president. So I think it's appropriate we do it for her again. We are to take some number of remarks. Just finished introducing the National Bar President. In line with the traditions of the Ghana Bar Association, even though she's the National President, once she has entered somebody's jurisdiction, she has to defer to the President of the region. So at this stage, may I, with respect, introduce my Regional President, Mr. Kwame Owusu-Sechere, to give us the remarks of the Bar. Welcome, Mr. President.
Thank you, my able secretary. Your Royal Majesty, Otumfuo-Osei-Tutu Asante-Hene, and a proud member of the Ghana Bar Association. And it is in this region that he was conferred an honorary member of Ghana Bar Association, of whom we are very proud of. Nana Chairman Ojia Hoho Yaojebi III, the chairman of this occasion, may I, with your permission, stand on the protocol already existed to make few remarks as had already been established. That is not by coin, a toss of coin that we are having this program here. And it couldn't have been better than having it here. Having received the August Nananom, distinguished academics, lawyers, jurists, celebrating 150 years anniversary of the Supreme Court of Ghana. Our Supreme Court of Ghana has done so well for the past 150 years, having the difficulty in sometimes being called upon to interpret the word or what is the meaning of shall, or what is the meaning of may. You have done this by ensuring also that when there was a difficulty in this nation, I remember the presidential election of the year 2012, when the atmosphere was charged, the Supreme Court of Ghana took charge and made everything as cool and peaceful as possible. And we are very grateful to the Supreme Court. Recently, we've had the problem of having the difficulty in what to do when it comes to sharing of properties when there is an issue about spouses. The Supreme Court had come in because Article 22(2) of the 1992 Constitution, which enjoins the legislature to pass a law to regulate spousal properties. They have not been able to do so. I don't know the reason why. But the Supreme Court stepped in And they've been able to, through the cases of Mensa and down recently, Yeboah, which is now the leading or the locus classicus in such a matter, they've been able to determine, even though the law has not been passed. So we thank you very much for the Supreme Court, and we thank you for the judges, and we thank you for the practitioners that had been practicing before this honorable court. My lords, in celebrating the 150th anniversary, I'm proud to say that within this region, we have contributed a lot to the celebration of this anniversary through lawyers who practice before the Supreme Court, and we can mention lawyers like Toto, Asumedu Sechi, Iye Meduse of blessed memory, and recently, if you can mention Papa Dasin, we can mention my senior Asante Krobia, we can mention recent new generation, my very good friend Mujib, Nana, your own lawyer, as having contributed. And to the bench, we have our Chief Justice, who is your son, being the Chief Justice. We've had distinguished members from the panel, the present juries, the judges that we have. Many of them have passed through your region and through your blessing. I can talk of, readily in this room, I can talk of Justice Esiedu, who was at Ashtown Court. Is now in the Supreme Court. I've also seen Justice Denis Ejei, who is also at the Supreme Court. He practiced here. He became the president of the Ghana Bar, and by your blessing, he has also assumed that jurisdiction. Justice Senor Damefe was here at the Court of Appeal, and by your blessings also, he has also been elevated. Justice, the chairman of the occasion, was at the KMA Court, one of the finest we can talk about, Circuit Court, and now chairing the 150th anniversary. I can go on and go on and go on, but Nana, this is because of your blessings and the way you have nurtured us. For the bar in the region, we have established cordial relationship with the bench. We are together, we pray together, we do everything together, but we are independent when it comes to administration of justice. And now we can assure you that we will never do anything that will bring disgrace to your region and your jurisdiction. As has been established by the chairman and the chairman of the committee, we are here in the region who has the foremost and most popular regional minister, Dr. Frank Amakohene. Together with his hard-working KMA boss, they are going to make sure that your stay here, particularly our judges who have come to the region, your stay here will not be in vain. And you are going to have a very memorable day being with the region. And I must be honest with you, our Chief Justice, Mrs. Hannah Taylor, has also been of good help to us, together with her team, right from the district to the High Court and the Court of Appeal, the President of the Court of Appeal. We have always had a cordial relationship, and now we can assure you that we will ensure that with your support, we are going to make sure that administration of justice in your region will flourish. And I want to assure all those practicing in this region that the Supreme Court will be your limit. Thank you very much for being here.
Thank you, my president. Since 2024, when we were in London in June, something happened that I've not told anybody, but because today you have opened the gate, let me say it. We went for the Ghana UK Law Week in June 2024, and we had a meeting with one of the biggest law firms. And normally what we do is that we go around the table introducing ourselves. And when he got to the turn of my president, he said, "My name is Kwame Osusetre. I'm the president of the Ghana Bar Association Ashanti, the king of Ashanti." is a member of the bar and he's in my region, so I'm the president of the king. Mr. President, I have done you in, forgive me. Honorable members, we shall proceed with our program and take the next remarks. But before I do, I would also like to acknowledge the presence of all justices of the Court of Appeal. My lords, may you rise so that we give you a round of applause. We are going to take our next remarks from the host regional minister, but I think it's appropriate that I also mention that he did not come alone. From the Ashanti Regional Coordinating Council, we have Michael Osu Amwakon Esquire, and we have the mayor of Kumasi. On the street, we call him King Zuba, but now that the king is here, I don't know whether I should still call him King. Zuba, after this program, I would find the proper terminology for you whenever the king is present. My lords, may we welcome the Ashanti Regional Minister.
Thank you. My King and Your Royal Majesty Otumfuo Osei-Tutu II, the Honorable Nana President Odiahoho Yaojebi, the second President of the National House of Chiefs and Chairman for this occasion, my uncle and my Lordship, the Chief Justice of the Republic of Ghana, the Judicial Secretary, Justices and Judges of the Superior and the Lower Courts present, members of the Council of State, members of Parliament, Nananom and members of the Traditional Council, heads of state institutions and security services present, the Mayor and MMDC is here, leaders and members of the Ghana Bar, officials of the Judicial Service, distinguished invited guests, friends from the media, ladies and gentlemen, good morning to you all. I, on behalf of His Excellency, the President of the Republic of Ghana, His Excellency John Dramani Mahama, and the good people of Ashanti region, welcome you all to this event and to the Garden City of West Africa, the City of the King. A round of applause for His Royal Majesty. Your Royal Majesty, I feel already like I'm in a witness box with the aura in the house and the presence of my Lord, the Chief Justice, and the Justices. In fact, yes, I'm in a witness box, but to witness history being made here and a milestone being celebrated here in the presence of His Royal Majesty Otumfuo. So on behalf of His Excellency the President, we want to wish you all a happy anniversary, and we say Ayiko for preserving the institution of the judiciary and the Supreme Court for 150 years. A round of applause for yourselves. This celebration is not just a passage of time, it is a celebration of our sacred national inheritance, carefully passed through dedication, wisdom, and the courage of generations of judges, magistrates, lawyers, and court officials who refused to allow justice to yield to fear, who refused to allow justice to yield to power or political expediency. They handed to us not merely an institution, but a legacy built on an enduring principle of fairness, integrity, accountability, and the rule of law. Every generation has a responsibility to preserve and strengthen the institutions that are bequeathed to it. Today, we honor the remarkable sacrifices of those who came before us, whilst reaffirming our collective duty to leave behind a judiciary that is even stronger, a judiciary that is more accessible, more efficient, and more trusted than the one we inherited. So on behalf of His Excellency the President, once again, we want to pledge, on behalf of the executive, that we do support and we are available to help in promoting same and in upholding the values as stated above. The importance of justices and the judiciary is not merely rooted in our constitutional democracy, but also deeply embedded in Scripture. Throughout the Bible, judges were appointed by God Himself to uphold righteousness, to protect the vulnerable, and to ensure that justice prevails over oppression. Moses is an example of a leader who appointed justices to judge amongst the people and ensure that the oppressed is liberated. Deborah, a strong female, stood in herself as a judge. Samuel also served as a judge and traveled throughout the lands to ensure that justice reached every community. These examples remind us that the highest calling of every judge is not merely to interpret the law, but to become the voice of a voice of fairness, a voice for the powerless, and the hope for the oppressed, and also the guardian of truth. That timeless responsibility remains just as relevant today. So whilst we proudly celebrate this remarkable legacy, we equally recognize that the pursuit of justice is a continuous journey of renewal. The expectation of every citizen of Ghana keeps evolving, and so should our institutions must evolve in line with those aspirations. We commend the Judicial Service for your significant progress made over the years in digitalizing in your e-justice initiatives, specialized courts, the improved case management systems, and the growing use of alternative dispute resolution. These reforms have enhanced efficiency, they have reduced procedural bottlenecks, and have expanded access to our judicial system to many Ghanaians. We encourage the continuation of these transformations, and we look forward to a judiciary that is even more decentralized, bringing justices closer to every district and to every community. This will reduce the burden on litigants to having to travel from long distances to seek justice. We envision a justice or a judicial system where cases are determined within reasonable time frames, because justice delayed most definitely remains justice denied. Also, we want to thank His Lordship, the Chief Justice, for a specialized course, especially on the issue of Galamsey. And equally, we will need more of specialized courts for sanitation, especially for our respective districts, since sanitation has become a key challenge in recent times. And we also encourage that the continued expansion of ADR mechanisms be enhanced across all levels of the judiciary delivery system. This offers a faster and a less adversarial and a more cost-effective pathway for dispute resolution. We also want to affirm that as young leaders, and also to my colleague young lawyers and the new generation of magistrate, judicial officers, and even law students that are gathered here today, you are not being prepared merely for a profession. You are being prepared to become a custodian of Ghana's constitutional heritage. The next chapter of our judiciary will not be written by the buildings and the technology alone, but by the men and the women whose integrity cannot be purchased, whose independence cannot be compromised, and whose commitment to justice will remain unwavering. The nation will judge the strength of our democracy not only by the laws we enact, but by the courage with which these laws are applied equally to the rich, to the poor, to the influential, and to the ordinary citizens alike. Your Royal Majesty, in conclusion, as we celebrate our 150 years of the Supreme Court in Ghana, let us renew our covenant with justice. Let us preserve the noble legacy handed over by those who came before us. Let us build a judiciary that remains fearless in defending our Constitution. Let us build a judiciary that is compassionate in protecting the vulnerable, swift in delivering justice, and unwavering in safeguarding the rights and the freedom of every Ghanaian. May future generations look back at our time and say that we did it not merely by celebrating history, but we equally strengthened it. On behalf of His Excellency, the President and good people of Ashanti region, we wish you once again a happy anniversary, and we say, Ayiko to you all. May God continue to bless the judiciary of Ghana. May God bless the Ashanti region. And may God bless our homeland, Ghana, and make our nation great and strong. Thank you very much.
Please, a big round of applause. Thank you very much to the Regional Minister of Ashanti Region. So years ago, the Chief Justice of Ghana started an initiative for some young girls in Ghana, particularly in Kumasi. And these are young girls we picked from the streets, some as kayayos, some as hawkers, who had no direction for their lives. And through the mentorship program, about 2 years ago, the president of the club graduated from Accra Technical University. I think the Chief Justice deserves a round of applause. His Majesty the King, these young girls, they've prepared as kids. They spent sleepless nights in rehearsals and all that, and they said they want to perform for all of us. Please, a big round of applause for these young ladies. They've done marvelously well. I would like to invite the Orange Girls to perform the skits. Thank you.
My bro. Hey, Minia. Hey, now where? Hey, now what's the Abba? Hey, there was some Naba. Hey, when him says, say, on him quakra, and say, they say on him for four, and they say, oh, says, say, Kojona said in the Alcuniano so. Koto Ben, nti ade amankwa yin na mu hu ye. Enti amankwa wa eden. Ka kwa say eden na wa ko man say mu bo amankwa di sa. Nti di amankwa mbeka se mu. Amankwa wa anya hwe se se okojo won na ye di hwe ofie won na se fata akunwa no. Enti won na o say di ni si o. Be we de me no nya adu wo de hwe ebusia fie a wo beti ase. Yo Nyankopon fa ye nkodru.
Ebushan free ye.
Ye mbra.
Ebushan free ye.
Ye mbra.
Say na ye nyina ye hia. Mo amunim say na na kwekura. Say ye hia mu say ye be yi hene foforo. Na na ye ma say wo ye panyin a wo kuro mi minim say wo bet mi gidi say wo bet me yi hene amaye.
Ebushan panyin me da wase. Pa cho so obi anim say me ye oba panyin wa ebushan yi mu. Ma say de say me yi na na esi anemu do bedi na ade na megidi se amankwa na se fata no de enti ameka san se amankwa ba akrom ha onna di mpuntujuma bebre aba akwan hina wona
pacho na na yema mentwawa no me pacho kojo de wo se wodi ade
no na na yema nkasa nwi ma
nya butre na menkasa amankwa ba akrom wonna eyi akwan nsuo wonna eye bibia mpuntujuma bia amankwa na eye kojo wo hoi na ejuma enso ani kakra no oye ontimi ma mpuntuo makro yi mu
nana yima ene mo wa onim se kojo na aju no so se yeso odi ade o ji amankwa di ade a eyeyie na so kojo na edi ade nana yima
enti ameka sa ne se kojo na ejuma na enso de ontimi ma mpuntuo makro yi so
kojo na aju na so se yeso odi ade
pacho mentwawa no kojo wona edi show krum ha wona wo se wodi ade no wona adu so
endru amankwaso.
Nana ebo ahanye di nana eba nana ebo nana Clacto nana Zonto nana eba ahanye di nana ebo ahanye di sumai na odi kuro no so no obekire nana dia wo so odi ahenie no munye di na muntie de obedi ahenie no nana boko nana bre nana boko sumai ni di nana ekwa abusuanum yan hwe de obedi hene sumai ni di ne ekwa abusuanum yan hwe de obedi hene sumai ni kaso nana kaso sumai ni kasa sumai ni se ha anya ha sumai ni se anya abusua we nana boko sumai ni di na kokodwo abusuanum yan hwe se ya omu na ombedi hene nana yan hwe se ahene ne ya omu de ana sumai ni kasa sumai ni se ne
The family is divided as to who is the proper person to see the chief. The case has traveled from the Judicial Committee of the Traditional Council to the National House of Chiefs. The appellant has filed an appeal at the Supreme Court of Ghana.
All right. Their Ladyship, Justices of the Supreme Court of Ghana, is sitting. Civil Appeal Number JC 001 Ebusuapeni Menu. Kwejo Mensa. Oba Penny Amankwa.
Any legal representation?
Yes, my lady. May it please the court. My name is Adiza Abubakar and I represent the appellant.
My name is Joeria Faisal and I represent the respondents.
Counsel for the appellant.
My ladies, this case concerns the rightful succession to the Abua Mines II. Chieftaincy, according to the 1992 Constitution, is the institution of chiefs and queen mothers recognized under customary law, and a chief is a person who hails from the appropriate lineage and has been validly nominated, elected or selected, and installed, skinned or installed in accordance with the relevant customary law and usage. The appellant submit that, according to the customary law and usage of Abua Amai, only members of Adontin royal family are eligible to occupy the stool. Their nominee comes from the appropriate royal lineage and was duly nominated by their kingmakers. We therefore pray this honorable court to affirm his entitlement to the stool. I pray accordingly, my lady.
Counsel for the respondent, you may proceed.
My ladies, The defendants respectfully submit that their nominee is a man of impeccable character who has rendered selfless service to the Aboaman traditional area for many years. He is highly educated, holding a university degree, and has used his knowledge and leadership to promote development within the community. He has funded educational initiatives, supported to the construction of community facilities, championed youth empowerment, and has always made himself available to serve the people. The respondents therefore contend that, considering his remarkable contribution, leadership qualities, and the confidence reposed in him by the people, this honorable court should recognize him as the proper successor to the stool. I humbly submit.
Having considered the submission before us, this court is guided by the Constitution of the Republic of Ghana, Article 277, defines a chief as a person who hails from the appropriate family and lineage, has been validly nominated, elected or selected, and installed, enskinned or installed as a chief or a queen mother in accordance with the relevant customary law and usage. The Constitution therefore recognizes that the office of a chief is determined by customary law, not popularity, wealth, influence, or personal preference. The evidence before this court established that Family A is the appropriate family lineage to nominate a successor. The court further finds that while the chief priest performs an important customary and spiritual function, he does not possess the exclusive authority to appoint a chief. Accordingly, judgment is entered for the appellant. The court directs that both parties should come together in unity to install the new chief and work toward peaceful coexistence.
Court now boys him now my family A.
Order.
Enti the court ni kena ni say munhwe na munsiesie esanse muina mufre ebusua baako.
Yo, the court as
All right.
And so justice prevailed. The family embraced each other and the rightful chief was installed. Today, as we celebrate the 150th year of the Supreme Court of Ghana, we celebrate an institution that has stood as a guardian of justice, protector of the Constitution, and defender of rule of law. Happy 150th anniversary to the Supreme Court of Ghana. Long live chieftaincy, long live justice, long live the Constitution, long live Ghana.
Orange girls, we are unique, we are the best, and we are proud of ourselves. Orange girls,
we are unique,
we are the best, and we are proud of ourselves. Thank you.
Please, let's do it for them again. That was a wonderful performance. A proper demonstration of courtroom practice. I am highly impressed and I am assured that the future is safe. Well done. Honorable members, we would continue with our program after that beautiful display by the Orange Girls. Next on the program, we will take remarks from the Chief Justice, but before my Lord comes, I will take this opportunity to introduce all justices of the High Court present. My lords, may you be upstanding so that we can give you a wave. The courts do not work just by judges. Judges work with staff. So in appreciating our judges, it is only fair and proper that we also appreciate our judicial service staff. And today being a biggest event like this, the staff could not have come alone without their president. With respect and rounds of applause, shall we give it for Mr. Samuel Afote Otu, President of JUSAG and a member of the Judicial Council of Ghana. We have other directors and staff of the Judicial Service of Ghana present. Can you rise so that we wave you? All Judicial Service staff. Wow, that's encouraging. Thank you so much for supporting this event with ushering and your attendance. We are also fortunate to have with us members of the Regional Security Council. All RECSEC members present, shall we see and welcome you. All other members from the security agencies, you are duly acknowledged. With a round of applause, shall we welcome the Chief Justice for his remarks.
The Orange Girls have reiterated what we say in Chi. The idea one know the from the skits that they performed, it was obvious that if Amankwa had any claim to any stool, maybe with the help of the rightful chief, he could be installed in Koswahi. For somebody who has brought Impuntu to the nation or the community, if the community recognizes that what we give you is in Koswahini or in Koswahima, not the Omahini or the chief of the town, you have to come from a proper lineage to assume the position of a chief. Another thing that I want to say is that the Ashanti Regional President of the bar implored us to socialize and then enjoy the life of in Kumasi. Yesterday I slept all by alone and all by myself. I have 2 more days to spend here, so maybe Nana didn't hear that. Your Royal Majesty, Otumfo Osetu Optimso Asantehene, the Honorable Chairperson, the Honorable Attorney General or his representative, the President of the Ghana Bar Association, Mrs. Ifwagati, my lords and ladies justices of the superior courts, may I specifically also mention the Lordship Justice J. Frimpong of the Supreme Court and chairman of the planning committee of the Supreme Court at 150, and members of the planning committee. The Honorable Regional Minister, Dr. Frank Amwakohene, the President of the Ashanti Regional Bar, Mr. Kwame Owusu-Tekyere, Nananom, distinguished traditional leaders, members of the bench and bar, members of the academia, distinguished members of the security services and the RegSec, members of the media, ladies and gentlemen, good afternoon. Your Majesty, some places call us to speak. Others call us to remember. But Menshia asked us to do both. Because Menshia is not merely a palace. It is a living archive of our people's memory. Its walls have witnessed generations come and go. They have seen triumph and sorrow, conflict and reconciliation, and those quiet moments when history turned on the wisdom of those entrusted with leadership. Here, yesterday is never entirely gone. It walks gently beside today and whispers to tomorrow. That is why it feels deeply fitting that as we mark 150 years of the Supreme Court of Ghana, one of our first major reflections should take place right here, not in a courtroom, but at Menshia Palace. For before justice wore robes, it wore wisdom. Before judgments were printed in the law reports, they lived in the memories of elders. And before our courts stood in the stone and mortar, justice often sat under trees, where truth was patiently sought, wrongs carefully weighed, and peace restored. Not because one side had won, but because the community had been made whole again. The forms have changed, Your Majesty, but the calling has not. And it is at this meeting point that the Supreme Court and the institution of chieftaincy find each other. One speaks through the Constitution, the other through custom. One draws its authority from the Republic, the other from the deep wells of history. Yet both exist for the same enduring purpose: to preserve justice, secure peace, and protect the dignity of every person. Honorable Chair, 150 years ago, a seed was planted. Those who planted it could not have imagined us gathered here today beneath its branches. They simply believed that justice deserved an institution that could outlast any single generation. Those who came after watered that seed with learning, strengthened it with courage, pruned its leaves through difficult decisions, and shielded it when storms came. Slowly, it grew into a tree whose shade now stretches across our entire republic. We honor those who nurtured it, not because they were perfect, but because they understood that institutions must outlive individuals. Their greatest legacy was not just the judgments they wrote, but the character they gave this court. Every generation leaves its fingerprints on the institution it inherits. Some strengthens them, others weaken them. History always tells the difference. Our generation now holds both the privilege and the burden of stewardship. The baton is in our hands. We did not start this race, and we will not finish it. Our duty is to run faithfully, to preserve what must be preserved, to reform what needs reform, and to hand over a stronger court to those who will come after us. That is how great institutions endure. Your Majesty, the institution of chieftaincy understands this truth perhaps better than most. Its strength has never rested in age alone, but in its remarkable ability to carry yesterday into tomorrow, without letting yesterday imprison tomorrow, to remember without becoming rigid, to evolve without forgetting who we are, and to remain rooted while still reaching higher. Every enduring institution must constantly answer the same difficult question. How do we remain true to ourselves while becoming better? That question faces the judiciary today, just as it faces traditional authority. As we celebrate this milestone, we do not gather merely to admire how far we have come. Milestones may matter because they remind us how far we still have to go. The greatest chapter of the Supreme Court must never be the one already written. It must always be the next one. That is why today's lecture is so important. Its subject goes beyond law. It is about the continuing conversation between two ancient and respected institutions that have shaped the conscience of our nation. One has spoken through stools, the other through benches. Both have answered the same human longing, that justice must be stronger than power, that authority must answer to principle, and that no society can truly thrive unless its people believe fairness still has home among them. Nananum, as Chief Justice, I come today not only to celebrate the court's history, but to express deep respect for the enduring contribution of the institution of chieftaincy to the peace and stability of our republic. Many disputes that could have burdened our cause are resolved quietly in our community through wisdom, patience, and reconciliation. The law recognizes this rule, and our nation continues to benefit greatly from it. As we look to the next 150 years, I pray that these two great institutions will continue, each within its constitutional mandate, to strengthen one another in the common pursuit of justice. For justice has never belonged to judges alone. It belongs to the people. We only hold it in trust, and trust built over generations must be guarded with the greatest care. The greatest inheritance of the Supreme Court is not its buildings, nor its history, nor even its judgments. It is the confidence of the Ghanaian people, the quiet assurance that when they enter our courts, justice will not ask who they are before listening to what they have to say. May that confidence never fade away. May that trust never be betrayed. And may those who come after us find the tree still standing, its roots deeper, its branches wider, and its shade even more generous than when it was placed in our hands. Your Majesty, distinguished guests, ladies and gentlemen, I warmly welcome you to this important lecture and wish us all fruitful reflections. May God bless His Majesty Otumfuo Osei Tutu Opimswo May God bless the institution of chieftaincy. May God bless the Supreme Court of Ghana. And may God continue to bless our beloved homeland, Ghana. I thank you.
Thank you very much. Thank you very much, His Lordship, the Chief Justice of Ghana. I am specifically touched by the work that he does for the Orange Girls. Thank you very much. Please, a big round of applause for His Lordship, the Chief Justice of Ghana. Nananom presents, distinguished guests, ladies and gentlemen. Our next speaker is a revered traditional ruler, an eminent statesman, a distinguished advocate for peace, education, culture, and national development. Through his visionary leadership, he has not only advanced the progress of the Asante-Man, but he has made an enduring contribution to the growth and unity of our nation. Nananom presents, distinguished guests, ladies and gentlemen, please, with a standing ovation and a round of applause, please let us make welcome His Royal Majesty Otumfuo Osei Tutu II, the King of the Ashanti Kingdom. Please, ladies and gentlemen, a big one for him.
Mema krobia irifia ngumani kotokungen. Mema krobia irifia ngumani kotokungen. Asante chantlo chmo champon fungen. Asante chantlo chmo champon fungen. Asante sesiebo sumendite. Asante sesiebo sumendite. Krobia santina je kasangen. Krobia santina je kasangen. Osechiche mimodi nyewisio. Osechiche mimodi nyewisio. Wain nebenya sejuso supani ni akraba kuma sika pobano. Wain nebenya sejuso supani akraba kuma sika pobano. Obinya sebianko bebi. Obinya sebianko bebi. Mena tedi fe badam de fe kasangen. Mena tedi fe badam de fe kasangen. Chewani ntofu moje nungen. Chewani ntofu moje nungen. Antofu dadi chmo champon nungen. Antofu dadi chmo champon nungen. Osoni krobio sumendite. Osoni krobio sumendite. Jakwe jale na adia sedingen. Jakwe jale na adia sedingen. Akusibio kumblo chmo champon nungen. Akusibio kumblo chmo champon nungen. Jakwe office frampo demri favisi. Jakwe office frampo demri favisi. Setutu mi modi nyawisio. Setutu mi modi nyawisio. Una na musuma nkabom empunto ne nkosoba wasantimam ne Ghana mayina. Una na musuma empunto ne nkosoba Ghana ni asantimamu. Obinya sebianko bebi. Obinya sebianko bebi. Lagwa bakaina ne frampo demri favisi. Lagwa bakaina ne from Po, Demi Ferisi. Emma Dabido, that quiet. Me Mount Dabindo, that quiet. Yeah, Domana, Yakubo, Jota, touch more champon. Yeah, Domana, Yakubo, Jota, touch more champon. Oh, Tosika, Samana, Jakunga. Oh, Tosika, Samana, Jakunga. Jacobo, Banco, John Flower. Jacobo, Banco, John Flower. And I pray from Po, Demi Fao. And I pray from Po, Demi Fao. Was I for Gunya was singing? Was I for Gunya was singing? Presentina J. Cassange. Oh, Presentina J. Cassange. Oh, great Tobago, the Fagunya was I do not chamera.
His Lordship the Chief Justice is requesting the use of this hall, and therefore they came to seek clearance from me. I said, who am I? I don't want to be charged for contempt. So please allow them to use the hall. Oja hoya JB. Mikrom here. Because that's where I was trained, so I always refer to him as my chief. He's the president and chairman of today's event. Your Lordship, Justice Bafuboni, Chief Justice of the Republic of Ghana. Nananum, Nanan Mahima, venerable members of the bar and bench, Excellencies, cherished citizens of our dear country, Ghana, ladies and gentlemen. I'm deeply honored to be here with other revered traditional rulers in the midst of this distinguished gathering, a special guest of honor to reflect with you on a subject that lies at the very heart of our nationhood, the relationship between the Supreme Court of Ghana and by extension, the judiciary of the Republic of Ghana on the one hand and the institution of chieftaincy on the other. On my part, my Lord, and I believe I speak for all of us, the theme for the anniversary, honoring the past, celebrating the present and defining the future, is eminently apt. Equally, the topic of today's lecture, the Supreme Court and the institution of chieftaincy, is particularly apposite. It is modern, born of constitutional and other legal design. Together, we have shaped the character of our nation's legal and cultural identity. Long before the colonial courtroom was built, as the Chief Justice intimated, the institution of chieftaincy stood as a principal organ of governance, justice, and social order among our peoples. The chief was and remains the supreme priest, judge, custodian of land, and symbol of the continuity between the living, the dead, and the yet unborn. Disputes were settled beneath the great tree, before the stool or the skin, through processes that prize reconciliation over retribution and community harmony over the vindication of narrow legal rights. The advent of colonial rule introduced a second parallel stream of authority, the English common law and its hierarchy of courts, with the Supreme Court eventually becoming the apex. For much of our colonial history, these two streams often run uneasily alongside one another. Chieftaincy was at various turns courted and co-opted through indirect rule. Yet it also had its judicial functions curtailed and its authority made to answer to a foreign sovereign and foreign law.
Sure.
Independence in 1957 did not resolve this tension so much as inherited. Successive constitutions grappled, sometimes uncertainly, with where chieftaincy properly belonged within a modern constitutional order.
Sure.
It is a matter of record that chieftaincy has, at different moments in our post-independent history, been sidelined by political actors who saw it as a rival center of authority. For instance, laws were enacted to de-recognize persons who, under customary law and usage, had been installed as chiefs. In the same vein, enactments were made to recognize persons as chiefs when they were not, by customary law and usage, qualified as such. Yet, chieftaincy has endured precisely because it commands legitimacy that no statute alone can confer.
Sure.
The 1992 Constitution marks the decisive turning point in this long history. Article 270 guarantees the institution of chieftaincy, together with the traditional councils, as established by customary law and usage, and expressly forecloses Parliament from legislating in a manner that detracts from or derogates from the honor of dignity of the institution.
Sure.
My Lord Chief Justice, this must serve as a notice to all persons, especially those of the bench and bar, that none are intimately familiar with the laws that concern the institution of chieftaincy.
Sure.
The institution of chieftaincy is therefore not merely tolerated by our modern constitutional order, it is entrenched within it and recognized as a co-equal pillar of our governance architecture.
Sure.
Yet, recognition alone does not resolve every question. It has fallen to the traditional councils, judicial committees of the Houses of Chiefs, and ultimately to the Supreme Court to give that recognition practical content.
Sure.
The Supreme Court has, over the decades, developed a substantial and increasingly sophisticated jurisprudence on chieftaincy matters, determining the boundaries of the exclusive jurisdiction of the judicial committees under Articles 273 and 274, the Chieftaincy Act, the relevant regulations and other related legal frameworks, adjudicating vexed questions of stool and skin succession, and referring the perennial disputes over stool lands to which our courts continue to devote considerable attention.
Sure.
In this role, the Supreme Court has acted not as a rival to Nananum, but at its best as a steadying institutional partner, a forum of last resort where the ancient wisdom of custom is tested against and reconciled with the values of our written constitution and other laws, including due process, non-discrimination, and the rule of law.
Sure.
Where custom is unclear, contested, or has evolved with the community that lives by it, the court has increasingly recognized its own institutional humility, deferring to those who lived and inherited knowledge of the custom in question, while standing ready to intervene where fundamental rights are genuinely at stake.
Sure.
We must be candid, though, about the strains in this relationship. Delays in resolving chieftaincy disputes, some spanning generations, have at times undermined public confidence and left communities without settled leadership for unconscionably long periods.
Sure.
Overlapping and occasionally uncertain jurisdictional lines between regular courts and the judicial committees continue to generate satellite litigation. These are not indictments of other institutions. They are the honest growing pains of two systems of authority still learning fully to speak one constitutional language.
Sure.
But I'm sure my Lord Chief Justice would agree with me that from Asante Mine we have we are not overburdening you with chieftaincy issues at the Supreme Court, because we're able to resolve them here amicably and everything is fine.
Sure.
So your workload from Asantman, let us do it, and then the others were confused and settle it with the
Sure.
And yet, ladies and gentlemen, today is rightly a day of celebration. We celebrate an institution of chieftaincy that has proven resilient, adaptive, and indispensable. The custodian of land and culture, the first responder in community development, and the moral voice invoked in seasons of national crisis. We celebrate a Supreme Court that has, notwithstanding the burdens of a young democracy, built a body of chieftaincy jurisprudence of genuine intellectual depth, one increasingly studied beyond our shores as a model of how modern constitutionalism may accommodate customary governance without extinguishing it. We celebrate above all the fact that these two institutions, the palace and the courtroom, have chosen dialogue over confrontation. The choice was never inevitable. It is the product of successive generations of chiefs, jurists, and politicians who understood that the strength of our republic lies not in the triumph of one system of authority over the other, but in their principled coexistence. If we are honest in honoring the past and clear-eyed in celebrating the present, we must equally deliberate in defining the future. Permit me to offer several reflections on the road ahead. The first is that the machinery of chieftaincy adjudication requires urgent modernization. The judicial committees of the Houses of Chiefs must be resolved, trained, and where necessary reformed so that chieftain disputes are resolved with the speed and finality that both litigants and communities deserve. Justice delayed in matters of stool and skin is not merely justice denied to individual claimants, it is stability denied to entire communities. Second, greater doctrinal clarity is needed on the precise boundaries between the exclusive jurisdiction of the judicial committees and the jurisdiction of the regular courts, particularly the superior court's supervisory and appellate roles. Continued dialogue between the bench bar and the House of Chiefs of the kind this very occasion exemplifies is essential to that clarity. And three, in Ghana, the final stages of process involved in the making of a chief is the process of registration of the name of the said chief in the National Register of Chiefs. The roles the various House of Chiefs play in this registration process deserves much consideration as a role these various houses, particularly the regional Houses of Chiefs, play in the registration process has sparked so much agitations and sometimes controversies. The provision of the law as contained in the Chieftaincy Act is that with the National House of Chiefs being the body charged with the responsibility of keeping the National Register of Chiefs in which particulars relating to a chief are recorded, whenever a change occurs in the membership of the Traditional Council or there's an occurrence of an installation, abdicating, or death of a chief, the Traditional Council of the area in question is duty-bound to report same to the Regional Houses of Chiefs, and the Regional Houses of Chiefs is in turn under a mandatory duty to report same to the National House of Chiefs for the necessary changes and recordings in the National Register of Chiefs. It must be stated for emphasis and for the avoidance of doubt that upon receipt of the CD form from the Regional House of Chiefs, it has a mandatory duty under the law to transmit the forms to the National House of Chiefs. The courts have stated time and again that the duty of the Regional House is to transfer the CD forms to the National House upon receipt of same and confirmation of its accuracy. It is a mandatory statutory obligation which cannot be flouted by the Regional House of Chiefs. The courts have also maintained relative to the duty of the Regional House in transmitting CD forms to the National House of Chiefs that no discretion arises unless there is a demonstrable legal impediment which the authorities have held to be death, abdication, and disposition. Consequently, the inevitable conclusion to be drawn from the above is that when it comes to the registration process, the CD forms pass through the Regional House of Chiefs, which acts as a conveyor belt or a conduit for transmission of the said forms to the National House for registration and nothing more. The fourth one, another issue of profound importance relates to land ownership within Asante Mine. Questions concerning the nature of allodial title, stool lands, and customary interest continue to generate significant agitations, uncertainty, and sometimes litigation. And I had the occasion to comment when I was at KNUST, where those lands have been bequeathed to the university, demarcated by my predecessor, who then was a surveyor before he became the Asantehene. And that was a barter trade between us and Osagyefo Kwame Nkrumah to establish that school for us. Some people have the irk and impudence from family heads or something to go and take it to court to ask for 1,000 and something acres of that school land. And with all due respect, my learned friends, some people also followed that. I believe that is wrong. First and foremost, it is imperative to state for emphasis that in Asante Mine, allodial ownership of land vests in the stools who hold same interest for the golden stool. There are no family allodial lands in Asante. Therefore, families and individuals cannot hold leasehold, can only hold leasehold or usufructory interest in lands in Ashanti, but never allodial interest in or title. Thus, if a person, a group of persons or family claims usufructory interest in land in Ashanti, same should be traceable to a stool, and that person, group of persons or family should be able to show at least a distinctive customary function that they play or perform as a person, group of persons or family to the stool, for them to continue to exercise their usufructory right over the land, but not allodial interest or title. And thus the Ashanti Confederacy in 1938 decided that all lands in Ashanti are vested in the stools in trust for the golden stool. This is our customary law, which is guaranteed by the Constitution. And please refer to warranty notes and you can find it there. Nana Chairman, the Supreme Court in conclusion, and more broadly the judiciary and the institution of chieftaincy are in the truest sense joint custodians of our constitutional order, one speaking in the idiom of statute and precedent, and the other in the idiom of customs and lineage, yet both ultimately in service of the same Ghanaian people. The past has tested this relationship, the present affirms it, and the future, if we are deliberate in building it as our ancestors and founders were in laying its foundation, promises an even more mature and productive partnership within the palace and the courtroom. I thank my Lord the Chief Justice for the honor done me in staging this celebration here in Kumasi, which I felt I didn't want any contempt, and so please come. I salute Nananom present with us today. I salute my lords of the bench and my dear brothers and sisters, the learned friends of the bar. I have the honor, and my wife too also, but when we are in the room, I speak law. I think in practice, Nananom also qualified to be referred to as learned as well. So, Mr. President of the bar, maybe, Madam President, maybe you will think about it. But I will caution not for them to use it for any wrongdoing. And I wish this occasion and the enduring institutions that celebrates long life and continued distinction. Long live the institution of chieftaincy. Long live the Supreme Court of Ghana. Long live our republic. Thank you and God bless us all.
Distinguished ladies and gentlemen, please join me in giving another resounding round of applause to His Royal Majesty, the King of Ashanti, Otumfuo Osei Tutu II. Your Majesty, we are deeply grateful for your wisdom and your support. Thank you very much. Please, it is now time for us to take another performance from the Justice Club of Prempeh College. Please, a round of applause for them.
Jana Yasasini, our land breathes true truth. Our rivers whisper justice. Our ancestors rise in silence. Today, we honor the reign of the Supreme Court of Ghana, along with the chieftaincy and justice system. Today is the day that have been made to tell our story.
Once upon a time, elders gathered beneath a tree or in the open space of a village, considering the grievances of men and women who sought justice. The widow whose farm had been taken after her husband's death. The farmer whose trusted friend had cheated him at harvest. The husband whose marriage had been a burden too heavy to bear. One by one they came with wounds, questions, anger, and with hope that someone would listen. There were no marble halls then, no wigs, no robes, no solemn cry of all rise.
Yet there was law. Law sat among the elders. Law listened through weathered wisdom. Law spoke through custom, proverb, memory, and through the sacred duty to restore peace. But when the matter grew too heavy for the elders, it was carried to the chief.
But when the chief himself stood between the people and their pain, who would settle the matter? Who could hear the voice that could not be heard in the palace? Who would weigh the widow's tears against the of the stool? Who could ask the strong to answer before the weak? Our fathers understood that a people must grow without abandoning their wisdom. And so we learned to transform. We learned that custom could meet written law. That the voice of the elders could find strength in the voice of the court. That tradition could walk beside procedure. Today, in the august presence of His Majesty, Otumfuo Osei Tutu II, occupant of the golden stool,
Nana Piao,
the Chief Justice, His Lordship, Justice Paul Bafuboni, Nana Nom, and the distinguished men and women of our land gathered here.
Nana Nom name penny for Yachiachiam.
We honor that ancient wisdom from which justice first drew breath upon this land.
Before the statues,
there was custom.
Before law reports,
there was memory.
Before the bench,
there was the stool.
I did not replace them. I grew from them.
For justice is strongest when tradition works hand in hand with procedure.
There had to be a place where grievances are taken to without fear. There had to be men and women trained to separate rumors from truth, accusations from proof, evidence from passion.
There had to be judges who would sit not in favor of wealth, nor in fear of power, nor moved by anything, but guided only by fairness, equity, and justice.
150 years ago, before the soil that would become Ghana, I was established. I found a home, not merely a structure of stone, not merely a place where disputes are argued, but as an institution called to serve justice.
I have stood through changing times, through the colonial rule, through constitution, written and unwritten, through the birth of a nation, through uncertainty and renewal, through struggle and silence. For 150 years, I have carried a sacred duty of justice.
For 150 years, I have called persons to account so that justice and equity may prevail and the society may rest in peace. But when the Constitution itself called for its guardian,
I answered.
When liberty was seeking for refuge,
I answered.
When democracy needed its true meaning,
I answered. Establishing precedence.
Into 4 verses, Attorney General, I reminded the nation that no office, however exalted, stands above the Constitution. For the Constitution do not bend for the convenience of men. Rather, men bow to the Constitution.
In the 31st December case, I reminded government that history belongs not to those who wield power, but to the republic itself. That democracy is strengthened not by uniformity of thoughts, but by the freedom to remember, to question, and to disagree.
In the Republic versus Tommy Thompson books, I affirmed that liberty must not be afraid of written word. That the nation confident in justice need not be afraid of ideas.
Thus I have spoken,
not for the government,
nor against government,
but always for the rule of law. I have suffered lash of criticism. I have suffered toppling of government when the power changed hands and the nation held its breath.
I have survived the shedding of my own blood. I remember on June 30th, 1982, where Justice Cecilia Crantain Ado, Justice Kwejo Eje Ejapon, Justice Frederick Pokusa-Akodie, and the retired Major Sam Akwa were taken in an act of violence which wounded the conscience of the people. Even though their blood poured out could not silence justice.
For justice can never be silenced or buried where truth still lives. Their sacrifice is a solemn reminder that the democracy of the independence can never be a privilege. It is the lifeblood of every constitutional democracy. I have suffered and I have endured heavy hands that try to pull me down and bury me beneath doubt.
Yet, I remain. I have survived the facelifts, the makeovers, changes in structure, changes in procedure, changes in personnel, and changes in time.
Yet, beneath every new appearance, my calling remains the same. To listen, to weigh, to protect and uphold the law without fear and favor.
I am the voice that says, bring your evidence. Let the other side be heard. Let justice prevail. Let truth be tested. I am the final court where the last question meets the law.
I protect the innocent.
I ensure that every guilt is never imagined but proved.
For every judgment may shape a life,
a community,
a family,
or even the destiny of a nation. So today, as I mark 150 years, I ask, will a nation, will a people permit me to stand still clothed in strength and dignity?
For when justice stands, the republic stands. I am the Supreme Court, and my work is not done until justice is allowed to finish its work. And today, please, let me stand for justice. Not for today's generation alone, no, but for generations yet unborn.
For 150 years of listening.
For 150 years of serving. For 150 years of defending the rule of law.
Permit me to stand so that everyone will learn. The judges, the leaders, the ordinary citizens.
Let justice stand. Let justice speak. Let justice live. Today, as we celebrate 150 years, we say, Ayiko to the guardian of the Constitution. Ayiko
to the keepers of truth.
Ayiko to 150 years of the Supreme Court of Ghana.
I am Edubrobe Kwadwompieni, the chieftaincy.
I am Edusei Kwame Michael, the law. And together we rule the nation with justice. Thank you.
I'm wowed by that performance, taking us through the various phases of the Supreme Court. Thank you to our honorable students from Prempeh College. Lawyer Silas Kwekuyebua Akuwa, thank you for assisting them. Teachers of the school, thank you for putting this together. We truly appreciate what you have done. We will take the next event, but before that, shall I take this opportunity to acknowledge the presence of judges and magistrates of the lower courts. My lords, if you are here, shall we see you on your feet so that we can welcome you. They are all judges and magistrates of the lower courts, that is the district courts and the circuit court. Thank you for honoring this event with your massive presence. I would also take this opportunity to humbly acknowledge the presence of Nananom Yamama Kwaba Yadamasenso. Then my colleagues at the bar, Ashanti Bar, you always do it and you make it great. My Lord, the Chief Justice, I have been told by my members and authorized to make an invitation to treat. This is not an offer. They just indicated to me that in 2024, they hosted a national bar for the conference and it was excellent. And as you can see, I am not sure we have had this attendance at any of the events since we started the 150th anniversary of the Supreme Court. We are just indicating to you that we are ready to host the judges. So if it is possible, let us have the Judges and Magistrates Conference in Ashanti region. This is an invitation to treat, it's not an offer. My Lord, thank you. I have given Asida, so you know it's sealed. Respectfully, honorable members of the Greater Ashanti Bar, shall we see you on your feet so that we can welcome you? Ashanti Bar is the best regional bar in the whole of the Commonwealth. It's confirmed. Thank you. We are gathered here to celebrate the 150th anniversary of the Supreme Court, but we are in Kumasi for a reason, and the reason is that for today, we are not just celebrating the Supreme Court, we are celebrating the institution of chieftaincy. And you don't talk of chieftaincy without mentioning Kumasi. One thing that is clear is that if everything has the national office in Accra, when it comes to culture and the National House of Chiefs, we have the national offices in Kumasi. That is an admission that Kumasi is the headquarters for culture and chieftaincy. Let's give it up to ourselves for that. For the next 45 minutes, we are going to have a lecture on the topic that we all know and have gathered here for. I have a very beautiful lady, a member of the Ashanti Bar, who is ready and willing to introduce our speaker to us. May I, with respect, invite Priscilla Adequatin to introduce to us the speaker for today's topic. Please, let's clap for her. She's beautiful, and I like the way she's walking. Welcome.
His Royal Majesty, Otumfuo Osei Tutu II, the Asante Hene, the Honorable Chief Justice of the Republic of Ghana, His Lordship Paul Bafo-Boni, and with due respect to already established protocol, it is my profound privilege to introduce to you the guest speaker for this august occasion. Our guest speaker for today will be speaking on the topic, the Supreme Court and the institution of chieftaincy, the past, present, and the future. Our guest speaker is the director of the Menchia Palace Museum. He was previously the director of the National Museum of Ghana. He has written on African art and architecture for the Commonwealth Heritage Forum and on UNESCO heritage sites. He has edited 4 anthologies of African short stories and has a poetry collection called Keeper of the Remains. He's a biographer of the Nigerian Nobel laureate, Wole Soyinka. He is lead editor of Crucible of the Ages, and with Professor Emeritus of Edmond College, Oxford, Lucy Newley, May Their Shadows Never Sink. He has served for years as advisor on international development cooperation to the former president of Ghana, His Excellency John Kufuor, on among others, the UN World Food Programme in Kenya and Ethiopia, and with the Geneva-based Interpeace. He also served as an advisor to the former UN Economic Commission for Africa Director, Dr. K.Y. Amwako. This is aside being a resident research analyst on Rwanda and in soft commodities and redevelopment of cocoa, coffee, and rice in La Côte d'Ivoire and Liberia. A historian of the Bank of Ghana, he wrote the 600-page Central Banking in Ghana and the Governors. His work in over a dozen African countries led to Africa, a Miner's Canary into the 21st, and his editorship of Pilgrims of the Night, Development Challenges and Opportunities in Africa, mainly contributed to by some faculty of the University of Oxford in honor of our former President Kufuor. In public service and international relations, he was deputy director and later served as minister counselor at the Embassy of Ghana in Washington, D.C., and at the High Commission in London. He was one of Washington, D.C. African Institution's anthologists on the foreign policies of 2 U.S. presidents called Assessing George Washington Bush Africa's Policy, Assessing Barack Obama's African Policy, and African Leaders. A fellow of the Council on Foreign Relations, he is editor of its journal, The Baobab. Ladies and gentlemen, our guest speaker has received 24 awards, honors, and grants from around the world, including the second African to receive the Distinguished Friend of Oxford and the Korean International Institute for Economic Policy. He is a member of the Order of Volta. He was a research scholar at the Hutchins Institute at Harvard and the Exeter College of Oxford. And for 4 years, he was a centenary research associate at the African Studies Center at the School of Oriental and African Studies in London. He holds graduate degrees from the London School of Economics, the School of Oriental and African Studies, and the University of Wales. His Royal Majesty, His Lordship the Chief Justice, ladies and gentlemen, I am certain that there's no better person to do us the honors to serve as the guest speaker than His Excellency Ivor Agyemang Duah. Please give a round of applause to him. His Excellency. You have to keep clapping until His Excellency gets in. You're welcome.
Good afternoon. Good afternoon. I don't know whether it's working. The matter with keynote addresses or lectures is that you don't get to be asked questions. In real cases, when questions are asked, they are outlets for escape. I will begin. The matter with keynote addresses or lectures is that you don't get to be asked questions. In real cases, when questions are asked, they are outlets for escape. Not being a lawyer, an academic in the discipline, or a jurist, I made such known when the invitation from the Supreme Court came. Second time trying. Yeah. The matter with keynote addresses or lectures is that you don't get to be asked questions. In real cases, when questions are asked, they are outlets for escape. Not being a lawyer, an academic in the discipline, or a jurist, I made such known when the invitation from the Supreme Court came. I was informed that I was invited as a contemporary historian, not in the sense of legal history, but nonetheless within the broader matrix of the social sciences. It is in this understanding that I find both my confession and my comfort in standing before you. We have come to know of two strands of history: Islamic history and ethos, which had been inspired by our pre-Gold Coast connections with the Sahel and other geographic regions, and Western or Christian historiography. The latter had been our folder or knowledge. Our varying trainings are connected to this. It could, in your case, be from the ancient learned discipline of philosophy and its evolution, the Greek philosophers who came before Marcus Cicero, Marcus Aurelius, and others of the classical regime. The continuation was through imperial and imperial days. The ultimate colonial heritage of modern law is about rules and regulations that order the desired behaviors we strive for in social relations that fell on us in another way. Societies existed long before formal legal systems and from the beginning of human community. We understood norms and obligations within our own geographic areas well before Ghanaian modernity or the last century of state formation. From the Akan forest states through the savannah into the Sahel, and back across the coastal belt from Keta through Accra to Axim, our people lived by laws rooted in custom, memory, and social order. There were European merchants and trade envoys all the way. The Portuguese, the Dutch, the Danes, the French, and of course the English, who built and inherited from amongst themselves in the 1400s the monuments of today. Yet, the very year they established a structure resembling a Supreme Court in 1876, exactly 150 years ago, was at a period in which areas that would later be assembled as the Gold Coast were actively resisting British ordinances, trade regulations, and land acquisition policies. Indeed, there was strong contestation regarding customary laws and traditions, whether in the northern parts in 1901 or earlier in the southern areas of the Akan states and the coastal regions. So these reflections will be snippets of historical recollections. So good were we with these modernist notions that we inevitably advanced in them. When the Supreme Court, constituted fully by the British, had operated for almost 20 years, there was the famous diplomatic delegation from the Asante Court that traveled to London, intending to protest against the invasion of Kumasi. Unable to initially find a native lawyer, the Supreme Imperial Commander, Joseph Chamberlain, ordered the invasion of Kumasi before the mission's return in 1896. The delegation had, prior to their return, found a Fanti lawyer from Anomabo, Kofi Asim, who provided the needed legal services from 1892 onwards. Others who support and got interested, including William Ado, Thomas Helton Mills, and Charles Bannerman of Accra. Though the last two were guards, they also traced their roots partly to the family of the Asantehene Osei Yawakutu, 1824 to 1833. That is, Osei Yawakutu is Otumfuo's direct matrilineal lineage. Other lawyers and intelligentsia, again, from the Cape Coast and Accra, will support this effort, not least the Fanti Africanists from the Gold Coast, J.E. Castley Hayford, who had impressively graduated from Cambridge University in 1893 at the age of 27, and subsequently from the Inner Temple in London. Though he was unable to do much, he tried again when he succeeded John Mensah Saba as president of the Aborigines Rights Protection Society, as counsel and a campaigner for Prempeh's return to Kumasi from exile in Seychelles, when he started practicing in the Gold Coast. Before this, the 20th king of the Gan state, Taki Tewia I, who reigned from 1862, defied British trade ordinances, policies, and taxes, describing them as exploitative, and refused their land acquisition request. He also refused to close strategic coastal trade areas to Asante. Described as uncooperative by Governor Hudson, he rejected an invitation to join the invasion and takeover of the Golden Stool, and described these as greedy British protocols. In 1880, he was exiled to Elmina until his triumphant entry to Gamashi in 1883 as an advocate against unfair trade ordinances before the World Trade Organization was established. And so, more than a century and a half after Samuel Rushdie's empire rise back, the cultural contestations were already underway, long before his treatise with an uneven scale that will tilt imperial justice for decades to come. In that same 19th century, the British historian Ivor Wells, in his comparatively little-known work, Wa and Walwali, Islam and Politics in Northern Ghana, of what he describes as a small but independent Wali politic, which was distinctive in the sense of its three authorities of king, imam, and chief. It had clear-cut constitutional provisions until the colonial intrusions and social disarray, not just from the British, but the French and its enclave in nearby Senegal, Mali, and Ivory Coast, especially in the 1930s. That it survived so long with these indigenous structures was a credit to its makers. Imperial institutions in history were not trustworthy. The first 70 years of the Supreme Court was a gloria to England's roses. It took over a half-century for the chiefs and people in Asante and the northern part of the Gold Coast to accept this 1876 Supreme Court, which, after all, discriminated against others from its supposed dispensation of justice. It was after 1927 when the first Asante lawyer, Sir Edward Asafo-Jay, started practicing in Kumasi and supported the Asantehene Prempeh II in the affairs of the Asante Confederacy Council from 1935 that some relief came. This was also, and at the time, the legal and cultural avant-garde, Sir Samuel Okai Kwashi Aiden, another collaborator of Prempeh II, who helped to establish the Cultural Center in Kumasi. That some foundational confidence was built in these British courts. It took another generation from the 1940s. Victor Owusu, Joe Appiah, Kwabena Kessy, Ifa, Thomas Toto, later Justice Edusei, Dr. Taylor, and others to give more confidence to this system. Victor Owusu at one time was described as the best lawyer Asante had produced. And when he passed, the national papers came to the conclusion that he was the best attorney general ever, which view was endorsed by the former president Nana Akufo-Addo. Joe Appiah, in the autobiography of an African patriot, recounted that they became so popular, these African Banglo lawyers, that when he traveled to do cases, he was met with brass band music procession to the court premises. He and his friends hardly lost cases. It had been a journey from 1876 situation of unbelief and unacceptability to eventual embrace. Since November 2008, Kumasi has had a Northern Appeal Court representing 9 regions. From the Asantehene Kofi Kakeri's hostilities to the British justice system prior to 1874 to Otumfuo Osei Tutu II has seen progressive growth and collaboration, including the latter giving acreages of prime land for construction of judicial facilities and courts in Kumasi. I will gladly recommend to you a manuscript I have had the opportunity of reading and soon to be published, a practical guide to legal professional ethics and advocacy by an appeal court judge, His Lordship Justice Nana Berimaya Okodia Opong, which looks into growth and decentralization. As for some of the practical and sensible recommendations he makes, you might as well find out yourselves. These moments and the individuals who shaped them have contributed to who you are today and of the early transformation of the Supreme Court. The Ghana Bar now numbers over 11,000 lawyers with few hundreds of judges. If we were to conduct a census of legal practice today, it is almost predictable that sooner rather than later, every household in this country could produce a lawyer. As I indicated earlier, in every era, whether ancient or modern, community systems regulated conduct and maintained order. In the medieval times in Africa and homewards to the Akan Forest states of the 1600s, emerged the kingdom of Denchra in today's western region, whose ruler was a formidable Buamponsim. He created traditional trade governance systems. In the opposite direction to the east, in what is today the small town of Akwemu, would emerge another traditional power with elaborate socio-cultural institutions. Komfo Anokye's dramatic meeting with the young Asante Royal Osei Tutu is well known. After the War of Liberation, as the story is all too familiar, the two came to the realization that what Denchra and Akwemu lacked were legal institutions to strengthen governance structures, what we may call today a constitution. They concluded that empires collapse easily and societies disintegrate quickly when civil wars arise in contests where laws are not codified, largely because such norms remain unwritten and unenforced. Bosman, the Dutch trade diplomat and envoy with considerable interest in trade law, was on record to have said that by 1690, Asante was virtually unknown. By 1701, it had become the most powerful state in the Gold Coast. Many commentators attributed this to the military structures Osei-Tutu developed to wage the wars, but more importantly, the legal institutions he later on built around them. The governance structures that evolved and the laws that regulated these, that is 300 years ago, were later on largely adopted by evolving traditional courts. That is the traditional laws and customs, the functional definition of marriage, family, social class, poverty, property rights, including land tenure arrangements and natural deposits and inheritance. Each of these norms had evolved from deep political and social anthropological values. The 777 laws of Okomfo Anokye constitute the corpus of Asante and to some extent Akan. We found similar developments around the coastal cultures from Keta through the Ghana states and the philosophical insights of others like King Takiteria. These norms have never been sacrosanct. They have undergone self-review, national reform, and constitutional amendments, including expansions of freedoms such as speech and religion, as well as the incorporation of international obligations grounded in fundamental human rights. When centuries later, we promulgated the Constitution of the Fourth Republic in 1992, we did not rely solely on inherited colonial knowledge or the professional expertise of the intelligentsia. We also drew upon the centuries-old traditions of chiefship, which the modern Constitution itself acknowledges and affirms. Some of the leaders involved in the making of the Constitution were themselves royals, grounded in these older traditions, yet carrying additional identities as modern professionals, including UN consultants. Among them was Nana SKB Asante, who led the process in 1991 as chairman of the Committee of Experts. I also recall another key figure who chaired the business committee of the subsequent Consultative Assembly, the Dwabinhini Nana Otiosrebo, who will later become the chairman of the Council of State, drawing on the same enduring values of the traditional past and heritage. There were members of the regional and national houses of chiefs involved, and if my recollection serves me right, the Ghana Bar Association boycotted the process. Some of your senior and diseased members felt offended with the inclusion of market women and traders for an exercise whose outcome had implications on them as well. The 1992 Constitution has endured for 30 years, the longest surviving constitutional order in nearly 70 years of post-colonial governance. And the Supreme Court has worked with it as faithfully and effectively as it could. On 2 occasions, when this country stood on the brink of presidential electoral disputes with the potential to descend into conflict and destruction, the court delivered stabilizing judgments rather than the partisan outcomes sought by either the MPP or the NDC. In doing so, it preserved the peace and safeguarded the republic. As we celebrate 150 years, we must remember the ancestral convergences, events, and cultures that directly or indirectly shaped this journey. Long before this moment, indeed, if we return to post-colonial times, we see that law, its interpretation, and its application were central forces that brought African leaders together in Manchester in October 1945 for the 5th Pan-African Congress. W.E.B. Du Bois attended, as were the emerging leaders at the time. Kwame Nkrumah as co-secretary, Julius Nyerere of Tanzania, Awolowo and Azikwe of Nigeria, Jomo Kenyatta of Kenya, Henson Banda of Malawi, who came to live in Kumasi at African Bungalow after the conference before he became the president of Malawi. There were also Joe Appiah Enakweje of Ghana, and the Great Caribbean Delights, C.L.R. James and George Padmore. Many of the 200 attendees were lawyers and law students, and Nyerere was so convinced of the importance of some of the Roman laws, including matricide and Africa's quest for independence, that he translated Shakespeare's Julius Caesar into Swahili. Even Nkrumah, solid as he was intellectually, thought he needed a PhD in law from the London School of Economics before finally coming home. If the Gold Coast and Africa were to be independent in the 1960s, it was not just on the face of it, as the same law was to be realigned for development. Land economy and ownership, which for centuries had been controlled by chiefs based on traditional family and state customs. How then will these realignments remain compatible with the transition from an agrarian economy to a modern system of estate and commercial production, one driven by cash crops such as cocoa for export and the rise of capital-intensive cultivation? A good part of the Supreme Court's work has also been the resolution of disputes over inheritance and claims to traditional leadership and land, matters whose potential to trigger conflicts has always been present. Every region in this country has had chieftaincy disputes ending up at the Supreme Court on these. And the most protracted one, including those of Gabon and Boko, until recently had been pending for over 70 years. Law and Supreme Court rulings could be another aspect of growth, from interest rates, balanced money supply at central banks, and international financial intermediation, with implications on loans and debt sustainability, all of which are getting complex. From when Queen Victoria's Jewish Prime Minister, Benjamin Disraeli, first used the sovereignty of the United Kingdom without paying a pound as a shareholding instrument or equity 167 years ago during the construction of the Suez Canal, it's become more than an economic intelligence or tool. The tool has developed legal rings in multilateral agreements. Many central banks today have large legal departments dealing with economic governance and interpretation by the Supreme Court sometimes. Notwithstanding that, we also know that systems are human creations. Opimso Osei the first understood these principles in the formidable laws he established. Yet, even that foundation, Ashanti experienced a prolonged civil war in the 1820s. And in the modern era, from the enactment of new laws in 1954, when Nkrumah became leader of government business, through the First Republic and into the Third, Ghana has witnessed repeated abrogation of constitution by self-styled liberation soldiers who replaced constitutional orders with decrees. In those circumstances, the maxim that the law is in the bosom of the judge could not hold. Instead, what emerged was Meltaldom in the bosom of the nation itself, culminating in the institution of Martyrs' Day on 30th of June 1982, in remembrance of the Jews who were murdered in cold blood. In the mid-1980s, the former president of the Ghana Bar Association, the distinguished Joe Appiah, reflected on the meaning of freedom in one of his short essays, Who is Free?, written in the aftermath of the murders of Justice Fred Poku Sarkodie, Justice Cecilia Cranton Addo, Justice Kojo Eje Ejapon, and Major retired Sam Akwa. He recounted an encounter with a commercial driver who had parked at a chop bar. His vehicle boldly inscribed with the haunting question, "Who is free?" When out of curiosity, he asked the driver what might have motivated those words. His countenance changed. He said, "You can see I am an ordinary driver, not usually counted among those who matter in this society. A few months ago, just before my uncle bought me this vehicle, it was reported that 3 High Court judges and a retired Army major had been abducted from their homes and brutally murdered and their bodies burnt. If these important people in the society can suffer such fates, who is free in this country? The driver told Joe Appiah. 150 years have given us pride in professional growth and have carried us through the challenging transition from traditional laws and ordinances into modern legal system. They have left us also with the enduring unanswered question, who is free? It is a question that continues to shape our understanding of the rule of law and judicial independence. It echoes through the experience of just and unjust laws, through the conduct of fair-minded authorities at the apex of public life, and through the postures of political apologists who stand on the horizon of national discourse. My grandfather, Thomas Boitin, a Chivili of the French Order of Arts and Letters, who co-founded the Alliance Française and was in the 1990s a close housemate of Kwame Nkrumah at Aggrey House at the Prince of Wales College, now Achimota School. He completed his studies with Kwabena Akukosa at the University of Durham in England at different times. When that generation returned to the Gold Coast, they reimagined an independent nation with integrity and boldness. Nkrumah appointed Sir Akukosa as his first Ghanaian Chief Justice in March 1957. It was a major phase of the Supreme Court's evolution. Akukosa knew the political temperature in Ghana in 1962, and the fact that he could easily lose his position, as Nkrumah was expecting nothing short of the conviction of all 5 defendants in the Kulungogo trial. A prelude to that situation a year earlier, in 1961, was the classical Ray Akoto and 7 others, which most of us learned in government studies, in which J.B. Dankwa, before the Supreme Court, was told that the Preventive Detention Act was not against the Constitution of Ghana, as Nkrumah thought so too. Akukosa's unconstitutional removal, which he anticipated, according to my grandfather's tale, was a sacrifice he made for what he called the ethical future. Supreme Courts can be vexatious, especially against political filaments that cannot sometimes afford restraint. The considered apostle of political liberty, Prime Minister K.A. Buzia, with his no court pronouncement against Salah, as the court sought to protect the independence of public service, was troubling, even if sometimes cited out of context, as some defendants say. It means the Supreme Court can participate in legacy labels that politicians without patient capital can regret, and then it gets registered not in the forgetfulness of history. If sometimes there is depreciation of boldness and integrity between the court and chiefship, as is imputed this day by some, the restoration of appreciation is in your hands. And the old fashion of integrity and boldness should still color the laws and judgments in your bosom. Of course, there has also been growth in hybridity, a fusion of tradition and modernity. We speak of alternative dispute resolution and have in our midst its most essential contemporary practitioner, your guest of honor, the Asantehene Otumfuo Osei Tutu II. We know it took almost a century to resolve the Dagon and Boko crisis. It ranged across the administration of 4 presidents of this republic for more than 30 years. Their final resolution through the Asantehene and his eminent chiefs, who endorsed many of the verdicts by the court, demonstrates how alternative sources of authority working together can secure peace. It showed that when customary leadership and traditional institutions align, durable settlements become possible. In what was an impressive remark the Asantehene made when presenting the report to President Akufo-Addo, he affirmed that nobody was above the laws of Ghana including the protagonists of the strife in the north, and including he himself. He added that by those same laws, whether understood in their traditional or modern senses, when his time comes and he departs, Asante Mine will endure, because the customs and traditions that brought him to the Skadwa or Golden Stool will be the same ones that will bring his successor. This sacred obedience to the law by kinship and the wise has been a platform for our common humanity. In a mightier precedence of over 800 years ago, it led to the almost divine gift to the world of the Magna Carta, one whose ever-moving spirit 163 years ago led to Lincoln's famous Gettysburg Address of "Our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal." This is immortal philosophy in law. Positions like those of the Asante and other traditional leaders should make the work of the Supreme Court a bit easier. In many other customs and traditions in Africa as well, we find that when traditional conflict resolution methods have been applied in collaboration with Western legal training, they work better. Or even if applied alone, they yield desired results. I sometimes work in Rwanda on economic development, a country many people cite as a demonstrative model that governance systems can indeed work. In doing so, many commentators overlook one of its most profound contributions, the Gagasa courts, based on an indigenous Rwandan concept focused on reconciliation and forgiveness, emphasizing voluntary acknowledgement of wrongdoing and restoration of relations. Without those indigenous mechanisms, and without the vision of leadership that guided it, Rwanda's story might have been yet another chapter of prolonged tragedy. Since you are here, of all places, you may be indulging a little proverb. Humenisumami tina chimi enunam. Antelopes walk in pairs, so one may rescue the other in time of danger or emergency. In his 2025 Nobel Prize in Literature acceptance speech titled "Enough About Angels," the Hungarian novelist Elke sought to deepen the meaning of this century-old proverb in his English cultural context. Cultivate friendship, maintain guiding relations rooted in old customs and traditions. For angels, he says, are difficult to find these days. You cannot answer to all the afflictions of illness, as you cannot also claim credit for many of the progressive developments over the years. But you can at least help to build on some of them. I don't think judges and lawyers are people who easily take the advice of lay people. And Otumfuo has given enough recommendation and advice on this in his remarks. So I will leave that as it should be. This probably is also my only opportunity to speak to you with confidence, even if with a touch of pomposity, if it comes across as such, without contempt being imputed to me. And I pray that nothing in this life will ever compel me to stand before you when you sit upon your benches. I do not intend to come to you by any chance. Happy celebrations.
Thank you very much, His Excellency Ivor Agyeman-Duah. Thank you so much for such insightful words. We will take another performance from some students of Prempeh College. Please, a big round of applause for them as they come. I'm sorry, please, from Kumasi Anglican School.
Your Royal Majesty, Otumfuo Osei Tutu II, Asantehene, the Honorable Chief Justice, His Lordship Justice Paul Bafo Boni, Your Lordship, Justices of the Superior and Lower Court, President of the Ghana Bar Association, the Honorable Regional Minister, Nananom, distinguished guests, ladies and gentlemen, a very good afternoon to you all. It is both a great privilege and a profound honor to address a distinguished gathering on the title, The Institution of Chieftaincy and the Supreme Court, the past, the present, and the future. The Supreme Court is Ghana's highest court in the judicial system. It is responsible for interpreting constitution, protecting rule of law, and serves as the country's final court of appeal. Its history reflects the political and constitutional developments from the colonial rule to the present. The Supreme Court traces its beginnings to 1876 when the British colonial government established the Supreme Court of Judicature for the Gold Coast through the Supreme Court Ordinance of 1876. The court replaced earlier colonial judicial arrangements and became the highest court in the Gold Coast colony. When Ghana gained independence on 6th March 1957, the Supreme Court continued to operate under this government. Military government occasionally suspended constitutional development, but the Supreme Court became one of Ghana's most important judicial institutions throughout history. The current Supreme Court operates under the 1992 Constitution, which came into force on 7th January 1993. From its establishment through the British colonial rule to its constitutional rule, the Supreme Court has risen and developed to be one of Ghana's most important democratic institutions.
The Supreme Court's bench and the Chief's 150 years together of harmony. Today, I stand before you to tell you a story of Lestool, a gavel, and a nation. A story of the past, the present, and the future. Long before modern courts were built, long before legal books were written, long before wigs and gowns became symbols of justice, there were chiefs. Chiefs who sat beneath the ancient trees listening to the voices of its people. They settled disputes, protected traditions, and preserved peace. They were custodians of culture, guidance of the land, and keepers of identity. The institution of chieftaincy was not merely a title. It was leadership. It was responsibility. It was service. From generation to generation, the wisdom of our sisters was carried through the institution of chieftaincy. But as time moved forward, our nation grew. New laws emerged, new systems developed, new challenges appeared, and then the Supreme Court stood tall, the highest court of the land, a symbol of justice, equality, and rule of law. Some may ask, can the traditional and modern laws work together? Can the chief stools and the judge bench share the same vision? The answer is yes, for both seek justice, both seek peace, both seek order. Today, the Supreme Court protect the Constitution, whilst the chief protect their customs and traditions. Neither replaces the other. Instead, they complement each other, like two strong powerhouses holding up the same house, the house called Ghana. Yet, the president brings some challenges: chieftaincy disputes, land conflicts, succession disagreements.
At times, these issues divide families, communities, and even the entire region. When such conflicts arise, the law becomes a guide. The Supreme Court helps ensure that justice prevails, not through anger, not through force, but through fairness, evidence, and constitutional principles. Because true justice does not shout, it listens, it reasons, it decides. And now, we look ahead to the future, a future where chiefs embrace innovation without abandoning tradition, a future where young people respect our culture while promoting development. A future where technology, education, and good governance work hand in hand with our cherished customs. The future belongs to us, the youth. We must respect our chiefs. We must obey the laws of our nation. We must become bridges between heritage and progress.
Because a tree without roots cannot stand, and a nation without justice cannot thrive. The Supreme Court and institution of chieftains are not rivals. They are partners. Partners in nation building, partners in peace, partners in preserving the Ghana we love. So let us honor our present, strengthen our past, and build a brighter future. A future where souls remain respected. A future where justice remains supreme. A future where tradition and law work hand in hand. A stronger nation is born.
Thank you.
Please, let's do it for them again. Earlier on, I stated that even though we have not signed a case completion plan, we are still managing time. So we are doing that. I listened to the guest speaker, and what he said got me marveled. It is said in Tree, Penny Jariria Nensuasa, but not at the law court. Once we have lawyers gathered here, we cannot let all that he said just slide. We would have to interrogate some aspect of it, highlight the key points that he made, so that we will leave here with a lot. We will do that, but let me acknowledge the presence of the first Deputy Speaker of the 8th Parliament of the 4th Republic, Honorable Joseph Osei Wusu. A proud member of Ashanti Bar. Ashanti Bar has a caucus in Parliament, for those who do not know. The last time I was there, he duly acknowledged my presence, and I was very proud as an Ashanti Bar member. May I also acknowledge the fact that we have some participants joining us online. So my lords, my friends, members of the bar who are joining online, you are duly acknowledged. We also acknowledge the presence of the media for your great effort. You have heard contempt several times. You are in the habit of taking pictures and not giving the pictures to the owners. Please, if you don't want to be in content, make sure you deliver the pictures to the people. They are not for you. Am I in your good books? Right. In line with protocol, I am informed that His Royal Majesty Otumfuo Osei Tutu II shall be taking leave of us at this stage. So shall we be on our feet with a standing ovation as we usher out His Royal Majesty the Asante Hene. together with the Honorable Chief Justice. And all Supreme Court justices, please, you are to be part of it. The program has not ended. We are going to have a panel discussion for 15 minutes to interrogate what was delivered to us by our guest speaker. Honorable members, we can take our seats. For those who just joined us, we have the washrooms at both sides of the auditorium. When you exit at the right side, straight ahead of you, you would have washroom. When you exit at the left side, it's the same. Can we please take our seats and take the next event? Whilst we settle, may I also acknowledge the presence of members from the academia. My own very good professor, Professor Chris Adomako-Kwakye is here. Shall we acknowledge your presence, sir? Right. As I indicated, we'll be using 15 minutes to dissect what was given to us. And considering the topic that we have just been lectured about, we are privileged to have with us a judge, a lawyer, and a chief to help us interrogate the issues raised. So our first panelist for today's event is Justice Nana Berima Yao Kodie Opon, Justice of the Court of Appeal. The law is taught at the school, but practiced before the court. So if we have a chief and a judge, it is only befitting that we get one from academia. Kindly join me to welcome Professor Chris Adomako-Kwakye as our second panelist. We are giving each panelist 5 minutes to highlight certain aspects of the presentation, and after that, we will take 3 questions from honorable members herein gathered. It is said in Chi, Mikobi na mankebi, yasini bibia. So once you are here, please say some. My lords and Prof, you're welcome. A lot has been said today, and we have been lectured, if I may put it that way. But what touched me from the presentation was the highlight of the work that the Supreme Court has done over the years. Nana, being a judge and a chief, may I find out from you first how the Supreme Court has impacted on the institution of chieftaincy for this 150 years?
Thank you very much, and good afternoon to my colleague judges, the lawyers, Nananom, and everyone here. I think sometimes we forget about what I consider to be, or those I consider to be the most important persons when it comes to administration of justice. And it's the citizens of Ghana. In actual fact, the work we do as judges was established by the people of Ghana, who are supposed to be the judges. But because all of them cannot be judges, they say justice emanates from them, but they have selected a few to do so on their behalf. So for me, the key people we need to celebrate, among others, my first choice is the citizens of Ghana, who have given us the work in the first place. But I will narrow it down to also those bold and courageous people who came to court in the first place. Because without the Bafo Akutos, without the Tufo, Amwaku Tufos, without the others who came to court, the Supreme Court couldn't have survived. Because if nobody comes to court, then there cannot be a court. We judges cannot refer cases to ourselves. If you are my church member and somebody is trespassing on your land, you just cannot come and see me to give you an order. You need to come to court and argue your case. And it is out of that we've been able to distill and fashion out the principles that we have today. In actual fact, if there were no litigants, the Supreme Court would have no work to do and wouldn't have survived. So let us not leave them out. It is because of them that we've been able to get this far. Even though we insist that as much as possible, disputes should be settled between the parties, we also need litigants to come to court so that we can settle with finality their disputes, even if we want to encourage settlement of cases in the homes. Now again, I would think that another aspect we need to look at is further decentralization of the courts. I've said it before when Otumfo donated a plot of land to construct a modern structure for the Ghana School of Law, that years ago when it was an abomination for lawyers to represent litigants in Kumasi, then it came to 1927, the chieftaincy institution was granted the opportunity to adjudicate on cases. There was one that started in the early days in 1927, and which I think arguably is the longest case, which ended up in 2023. 96 years of one dispute. Well, let me be boastful. I was happy to say that I won it for my client. Anyway, so the chiefs have been involved. Some of the cases had to be enforced by the chiefs. You mentioned the Dabon dispute cases were mentioned. After the years of adjudication by the court, it still took traditional leaders to ensure that the judgments issued by the court were enforced. And so I think that, without sounding repetitive, it should be important for us that if nothing at all, chieftaincy cases that have been determined by the National House of Chiefs should not be taken to Accra. There should be possible for the Supreme Court to sit in Kumasi and determine it. And I may add to that jurisdiction, even sit on land cases that have commenced in courts in the northern part. To end here, this may sound strange, but as I said, if from the beginning it was trained for a lawyer to represent a person in Ashanti region, now we had a district court, circuit. Court of Appeal used to be in Accra alone. Nobody ever thought of it being taken to Kumasi, even there was a time we used to sit in Koforidua. We still do, but online. So my point is, if we need to decentralize the judicial system, we should also consider even if not a building in Kumasi to serve the northern part as Supreme Court, at least there should be Supreme Court sitting over cases that have been determined here without it having been brought to Accra. And I think to a large extent, the load will be reduced. Of course, it will also give opportunity for many judges to be appointed to the Supreme Court. If it comes to me, I will accept it. Thank you.
Thank you, Nana. Prof, let's take it from the side of academia. Let's look at the contribution of the Supreme Court to our jurisprudence, how the court has helped to shape our jurisprudence over the last 150 years.
Right, thank you very much. And once again, I'm grateful for the opportunity given to me. Now, with respect to disputes, to the extent that one party is not satisfied, it is better to continue and reach the apex court rather than resort to self-help or violence. And so when we look at a lot of decisions, although some decisions reach the Supreme Court, the court will make a determination, but still you would have some challenges. And
microphone.
You would have some challenges. And I can cite two examples. We can look at the Dabon case, where it was determined by the Supreme Court. I mean, we were all supposed to see that that was the finality, but there were still misunderstanding. And it took the role of His Majesty and other eminent chiefs to resolve that particular issue. There are also instances, at least in Kumasi here, I can mention the late Nana Ponko Bafo. The Supreme Court made a determination, but after that determination, there was still misunderstanding. And it also took the intervention of His Royal Majesty for him to leave, and then there was peace. So the Supreme Court has assisted us. That's why nobody can run away from it. But there are instances where, as a final appellate court, a decision will be given, but still there would be a misunderstanding. At least in school, we say that until that precedent is, the Supreme Court gives another decision, we are all bound by that particular decision, and then we all know the principle of judicial precedent. So it has really helped us. It has really helped us in so many areas of our lives.
Thank you, Prof. Before I take questions from the other members present, Nana, I want to come to you again. When you take a look at Ghana over the last 150 years, we have gone through turbulent periods. I am wondering how the Supreme Court has been able to survive for all these years in the face of all these difficulties.
Well, thank you very much. Number one is because we have men and women as citizens who are prepared to even become martyrs for their own integrity. Personally, they are prepared not to sell their conscience, and they are prepared to even maintain their own positions on a matter to the extent that they understand the law. No political or other forms of interferences have pushed them to rather give a decision that everybody can maybe say that this was outrageous or a travesty of justice. So we are lucky in this country to have such men and women. So even when 3 of them were murdered for speaking the truth to power, none of them really became afraid or were prepared to just save their lives instead of their job. So they pursued it, and through military rule, through threats, and all the indications of interferences, they continue to serve the nation. In other countries, you may not have such bold men and women. We are lucky to have them, and that is our pride. Without that, there's no way we could have come this far with the Supreme Court being 150 years today, and we having heard very little criticism from genuine personalities. Some say that some people have lost trust in the judiciary, but I say on the contrary, not because I'm one, but if you open another 100 courts today as we did 2 years ago, those courts will still be full. It's a testament to the fact that Ghanaians understand that it is the court which is the place they will go for justice. And they know that if they fail at the Supreme Court, probably they will have to leave it to the Lord in prayer.
Thank you, Nana. Nana, before I come back to Prof, may I take questions from members present? Please, any question? We are at Mensia. And to wait, we will question Uchi. Yes. Any question from the floor? I take it that there's no question from the floor. Prof, I will take a very last one from you. What suggestions, if I may put it that way, would you make going forward? We are looking at the next 150 years. Where do you want to see the Supreme Court?
To add to what Nana said, it is to see them making sure that the law is interpreted to affect positively every development that's supposed to be done in the country. And when the speaker was speaking, he mentioned the relationship between law and development. And then I also listened to the fact that chiefs are those who own the land. At least in Ghana, we know that natural resources, the commission that was passed in 1950s, presided over by Boating Commission, vested all natural resources in the state for the benefit of the people. With respect to how we can rely on these natural resources for our development, there is a missing link. And the missing link relates to how we have failed to use the law for purposes of ensuring that we get the needed benefit from our natural resources. We have law firms in Ghana. Anytime that a multinational would want to come and invest in Ghana, they engage them. Look at your laws. I want you to advise me in this particular area. The advice that goes, and then when they are coming to sign any agreement, you cannot go out of the law. And so we need to make sure that the international norms with respect to exploiting natural resources is part and parcel of our law. And in looking at that, the Supreme Court is a place where some of these legislation can be tested so that we get the benefit of the natural resources as well as the land that is there. A typical example is Uganda. When they found oil, they decided that we need to commission a study. And the study, one of the suggestions they got was that it is important for you to ensure that the resources, part of it, stays in Uganda and refined for the East African community. A lot of multinationals, they came around, they did not agree to that. But eventually they were able to get another company that agreed that we would make sure we give you something that you would refine for the community. And I think that some of these things, my plea to the chiefs is to start the advocacy and ensure that whatever is on their land, what is the nature of the law. And I think that if there is anything that is to be done, the Supreme Court will be prepared to ensure that that particular piece of legislation is also interpreted to suit the benefit of the individuals
who reside in that particular community.
Thank you, Prof. Nana, your last words, and in giving your last words, if you may also highlight on how we can deepen the relationship between the Supreme Court and the institution of chieftaincy.
Well, my last word is to rely entirely on the speeches that have already been given, and I have nothing more useful to add. Thank you very much.
Thank you. Shall we give it for our panelists? Thank you, Nana. Thank you, Prof. At this stage, I also have nothing useful to add. I would invite the chairperson for the planning committee, my Lord Justice. Very well. My Lord says I should rather invite the chairperson for today's occasion. Omaihene of Sefi Anyaso Ojiahoho Yao Chibi for his closing remarks.
Thank you very much. Otumfuo Osei Tutu II, King of Asante, and our special guest of honor, my Lord Justice Paul Bafuboni, Chief Justice of the Republic of Ghana, Nananom, Nana Himanum, here present, eminent members of the bench and bar, Your Excellency, distinguished ladies and gentlemen. My reflections on the morning's proceedings. We have this morning been the beneficiaries of a rare privilege. It is not often that a gathering such as this is afforded the opportunity to hear from the very seat of traditional authority, so candid and so illuminating an account of the bond between the palace and the courtroom. Otumfuo Osei Tutu II has spoken to us not merely as a monarch, but as a custodian of history and a partner in the continuing project of nation building. And His Majesty's reflections will, I have no doubt, occupy the thoughts of all of us present long after we have departed this hall. That address found its complement in the keynote lecture of our distinguished historian who traced with such scholarly precision the long and intertwined path of chieftaincy and the judiciary across a century and a half of our nation's constitutional life. Between His Majesty's address and his lecture, we have this morning been given both the lived wisdom of the institution and the considered judgment of the academy, a fitting pairing for an occasion of this historic weight. I think this family, it is because if you heard all the speakers, they were so distinguished that I find it very difficult to add anything to what they have said. So I'm here only to praise them and to draw your attention to the fact that we must live by what they have said to us, especially to my revered chiefs. If we remember what Otumfuo said, why should we keep documents for registration of chiefs? Why should we keep them? It is a process. If the appointed, not judicial committees, the appointed kingmakers indicate that so and so is the chief of this, and you have the documents, it is an obligation on you to submit same to the regional House of Chiefs, and the regional House of Chiefs should also submit same to the National House of Chiefs. Nananom, it's unfortunate, but I'll raise this issue in the last week of this month when the House meets. And let me emphasize that even before I came here, I heard that there are certain regions in this country where only a few of our chiefs have been registered, just because they have to do something before they get registered. That is not what we are supposed to do. So I plead with you, let us be careful about this and let us learn a lot from what we have said today. We have heard today. Vote of thanks. Otunfo Osei II, our special guest of honor. I extend the profound gratitude of the National House of Chiefs, and I dare say of all gathered here, for the singular honor His Majesty has done this lecture series by his presence and by the depth of his reflections. To our distinguished historian who prepared and delivered this morning's keynote with such evident scholarship, I offer our sincere thanks for a lecture that will long be remembered as a landmark contribution to this 150th anniversary series. To my Lord, the Chief Justice, and through him to the entire judiciary, I extend our profound gratitude for the honor done to the chieftaincy institution in the very conception of this lecture series, that the custodians of our Constitution should turn at this 150th anniversary moment to consult with the custodians of our tradition is itself a quiet but powerful affirmation of the co-equal standing of our two institutions. Nananom, and then to the government, I really appreciate that we had the regional minister here representing His Excellency, the President, and I believe we have a few members of parliament here. It is quite regrettable that right from the colonial days through Kwame Nkrumah and to date, I don't know whether it is the deliberate attempt to silence Nananom or what. Because why do I say that? We own the land, we own everything. Unfortunately, even though they say Nananom have control over have surface rights, that is not determined. When mining is done in areas, Nananom are not giving anything. As I speak, Nananom are giving only 8% of the royalties accruing from mining in Ghana. And that 8% does not go to only the stools. Assuming we have 1 million royalties paid by a company, 8% of that 1 million is $80,000. And the $80,000, administration of Sioux Lands takes 10%, which is 8,000. We are left to 72,000. That 72,000, 55% goes to the municipal district assembly. So we are left with about 30,400 for the landlord. And it's not only for the landlord, it is for the landlord and all the people in that area. So it is unfortunate when you are endowed with resources in your area, what it means is that it's a curse because your area does not get anything. So the politicians who are here, we are telling you that you should have Nananom involved in the allocation of resources. You should pay Nananom or allocate a lot of resources to the areas that we get the minerals. In Senegal, for example, all mining companies are expected to pay into a fund 5% of their gross revenue for development of the affected areas. In Congo, royalties 35%. In Nigeria, it's 30%. Why is it only 8% in Ghana? And aside of that, the small allocation of resources to Nananom, these resources are also withheld over months and years. As I speak right now, the whole year, we have just received the first allocation. Meanwhile, people go around accusing Nananom that we are not proactive. All disturbances are attributed to chieftaincy and so on and so forth. We are not resolved. If we were to be resolved, then of course we'll be proactive. Wherever we cited anything, any wrongdoing or some smoke, Nananom will rush to those areas and resolve the matters. As I speak, Nananom are here. When they attend meetings in Kumasi, they are giving 300 Ghana cedis for hotel, 300 Ghana cedis, including myself. And the certain allowance to is 300 cedis to me, 250 to my vice, and 200 to members of the National House of Chiefs. I am raising these issues because it is not as if Nananum are not interested in the disturbances going around all over the place. But when I get a gathering like this, I share these values with you because we have the parliamentarians among you, we have the lawyers, we have people in the executive among you. So we are pleading with our executive and the legislator. Please get Nananum involved in the allocation of resources. To Nananum and Nana Ahimaram, I offer thanks for gracing this occasion with a dignity that only their presence can confer. To the learned bench and bar for your seriousness with which they have engaged this morning's proceedings, and to your excellencies and distinguished guests for the courtesy of your attention throughout. To the organizers and planning committee behind this successful anniversary, I say Ayiko, and we thank you very much for involving Nananum in this. My closing charge, as we now bring this second lecture to a close, let us carry with us not merely the memory of an elegant morning, but a renewed resolve that the partnership between the palace and the courtroom, so ably illuminated today, might continue to be nurtured, honored, and strengthened in the service of Ghana, whose past instructs its present and whose present shapes its future. I thank you all for your kind attention and wish you a safe journey to your various destinations. God bless you.
Your Royal Majesty, Otumfuo Osei Tutu II, Your Lordship, Justice Paul Bafo-Boni, Chief Justice of the Republic of Ghana, Your Lordship, Justice Richard Ejei Frimpong, Chairman of the Supreme Court at the 150th Anniversary Planning Committee, Mrs. Ifwagati, President of the Ghana Bar Association, the Honorable Dr. Frank Amwako-Hene, Ashanti Regional Minister, Justices of the Superior Courts of Judicature, Judges and Magistrates of the Lower Courts, the President and Executives of the Ashanti Regional Bar Association, former leaders of the Bar, distinguished members of academia, Nananum hearing present, senior colleagues and members of the Bar, distinguished invited guests, ladies and gentlemen. I am Ethel Jobson Mitchell, and it is my singular honor on behalf of the Supreme Court at 150th Anniversary Planning Committee to deliver the vote of thanks at the conclusion of this important and historic lecture. First and foremost, we express our profound gratitude to Your Royal Majesty, Otumfuo Osei Tutu II, Asante Hene, for graciously accepting to serve as a distinguished patron of this lecture and for hosting us here at the revered Menchia Palace. Your Royal Majesty, your presence has clothed this occasion with exceptional honor, cultural significance, and royal dignity. Through your wise and distinguished leadership, you have remained a steadfast custodian of our traditions, a champion of education and development, an advocate for peace and reconciliation, and a respected voice of unity within Ghana and beyond. Your Royal Majesty's commitment to justice and peaceful dispute resolution makes your patronage of a lecture on the Supreme Court and the institution of chieftaincy particularly meaningful. Your Royal Majesty, may your reign continue to be long, peaceful, and prosperous. We are equally grateful to your Lordship
Justice Paul Bafuboni, Chief Justice of the Republic of Ghana, for honoring this occasion with your presence and for your leadership in the judiciary. Your participation underscores the importance of the lecture series and the judiciary's commitment to reflecting upon its history while preparing for the demands of the future. Our sincere appreciation also goes to your Lordship, Justice Richard J. Frimpong, Chairman of the Supreme Court at 150th Anniversary Planning Committee, and to all members of the committee. Your dedication, careful planning, and tireless efforts have made today's event possible. We commend you for conceiving a lecture series that not only commemorates the past 150 years of the Supreme Court, but also creates an important platform for national reflection and dialogue. To our distinguished keynote speaker, His Excellency Ivor Ajimandia, we extend our heartfelt gratitude for the insightful and thought-provoking lecture delivered on the topic, the Supreme Court and the institution of chieftaincy. Your lecture has deepened our appreciation for historic relationship between the judiciary and the institution of chieftaincy, and has challenged us to consider how important institutions can continue to contribute to justice, peace, and national development. We also express our sincere appreciation to our chairperson for the occasion for expertly guiding the proceedings, and to the distinguished panelists for enriching the discussion with their perspectives, experience, and thoughtful contributions. To the Honorable Ashanti Regional Minister, the President of the Ghana Bar Association, the leadership of the Ashanti Regional Bar Association, members of the judiciary, traditional leaders, members of academia, the security agencies, and all invited dignitaries, we thank you most sincerely for honoring our invitation and lending your presence to this historic occasion. We acknowledge with gratitude the contributions of the Justice Clubs of Prempeh College and Anglican Senior High School, as well as the cultural performances, whose performances brought color, energy, and youthful inspiration to today's program. Your participation reminds us that the preservation of our institutions and democratic values must involve the next generation. Our appreciation further goes to the Masters of Ceremonies, the planning and protocol teams, officers, and staff of the Judicial Service, the media, the security personnel, technical crews, ushers, caterers, and all individuals and organizations who work diligently, both publicly and behind the scenes, to ensure the success of this program. To every guest who joined us today, we are grateful for your time, attention, and participation. Your presence demonstrates the collective importance we attach to the Supreme Court, the institution of chieftaincy, and their continuing roles in Ghana's constitutional and democratic development. As we celebrate 150 years of the Supreme Court under the theme, Honoring the Past, Celebrating the Present, and Defining Future, may we live here inspired to protect the rule of law, strengthen our institutions, and preserve the values that bind us together as a nation. Once again, on behalf of the Supreme Court at 150th Anniversary Planning Committee, I say thank you, Madam Mwase, and may God bless us all and our homeland, Ghana.
Thank you very much, Ms. Ethel. I would like to invite Reverend Mrs. Teresa Appiah-Dedu to give us the closing prayer. Please, a round of applause for her as she comes on stage.
Shall we humbly bow for a word of prayer? In the name of the Father, and of the Son, and of the Holy Spirit. Our heavenly and gracious Father, we thank you for a successful meeting with us today. Thank you for the deliberations that were shared, the fellowship we have enjoyed, and the hearts that have been uplifted. As we leave here, we do not leave your presence. We pray that you shall grant us the traveling grace to every destination. We pray that the next 150 years of the Supreme Court will be graceful, will be impactful, and will be glorious. Protect our families, guide our steps, and give us the strength to serve you in love and grace throughout the week and the prevailing months. Now the Lord bless you and keep you. The Lord make his face shine upon you and be gracious unto you. The Lord turn his face toward you and give you peace. May the grace of our Lord Jesus Christ, the love of God, and the fellowship of the Holy Spirit be with us now and forever. Surely, surely, goodness and mercy shall follow us all the days of our lives. In Jesus' mighty name, amen.
Bless you, Auntie Abrifri. Honorable members, this is where we draw the curtains. We are grateful for your time, for your patience, and for your contribution to the success of the event. The MCs are grateful for allowing us to be your MCs, and may God bless us all. Thank you. We will be taking group pictures. So Nananom, if we may have a group picture. Please, it's time for the group pictures. My Lord Justices, if we may gather here for the group pictures together with Nananom. Nananom, please do us the honor. All judges are to come up here for the group picture. All judges are to come up here for the group picture. All judges are to come up here for the group picture.
Respectfully, my lords and ladies, we have very important announcements to make regarding tonight's event. So we would crave your indulgence not to leave. We will be meeting behind the foyer in a holding room. My lords and ladies, respectfully, don't exit